All right, as you can see up on the screen, we are live streaming today. This is part of the notice. I've gotten feedback on that. I wanted to let you know. Many of you may be asking, why are we doing this? Look, I believe that our system is under attack. I'm looking over at the attorneys. You know that half of the country believes that the courts are used wrongly to attack one person. The other half believes it's for another person. But what we know at these courts, and I know this, is that when people come in and see what we're doing, they see how you are defending people, attorneys, protecting their constitutional rights. They see this process. They believe in our system again. And so that's what this live streaming is about. It's about letting people see what we're doing. And I hope bringing confidence back to our courts. Because when people come and see it, they believe it. You've seen the students here that come to court often. They come from Texas State. When they walk out, what they've thought from social media or what they've thought from the media is totally different once they see what our courts are doing. So let's give people that opportunity. That's the idea. The other thing is, I was just down in Peru, and down there they are shifting from the system of an inquisitive system, a Spanish-based system, to the American-style trial system. And that's because they want transparency of the trial system, of what it is we do. We take it for granted. And those people want it so much that they invite us down there to talk about it. And our Constitution, after all, says all courts shall be open. They say, well, they're open and you can come in and you can be in court, right? That's enough. And I want to take you back, especially you defense counsel, when you think about this. Before Gideon, there was the question of the right to counsel. And people would say, well, the defendant had the right to counsel. He just didn't get it. Well, is it really a right if they can't afford that? And that's after Gideon, that changed everything. I think that's the same thing on the right to access. People have the right to access our courts. But if they can't actually come here because they have a job from 9 to 5, or if they are a student and they have to be in class, or they're a mom that has kids but wants to know what we're doing and hear about the fentanyl crisis, they can't really come. So what is the right to access if they can't come in and actually see it? That's what I think we're doing, is we're giving them an opportunity. But I don't think, look, I know there's some concern of some of you about this. I don't think you should be concerned. I have found that this bar in Hays County is incredibly competent and good at their job. Nothing's going to change. We're going to continue to do things the right way. And you will too. The attorneys who work for the indigent clients, who take appointments. We're so lucky to have you in Hays and what you do. I see you fight for them all the time. I appreciate y'all. Let the people see, but it's not you, for the most part, that are complaining about this. It's not you, it's the defense bar hasn't said that much. One of your colleagues even said, I wrote it down, I read it in the paper, I think the judge is trying to do what is right to show the people the inside of the court. And that is what we're trying to do. And what's the problem there? If people see the inside of the court and they want to hold us accountable, let them do it. It opens me up. Why would someone not want to be open and see what we're doing as elected officials? Here's the thing. If a party attempts to overcharge your client in order to get a plea, is that justice? I didn't stand for it last week, and I'm not going to. Building leverage against a client is not the way the process was intended to be. It's only through due process. Proving someone beyond a reasonable doubt, not because you've stacked more counts against them. And so I said I wouldn't allow it last week. Was I wrong? Well, maybe so. If it's on the system, people can look at it and they can decide. I know that people will come after me. But I believe in the transparency. You can hold me accountable. This, what I'm doing, I'm trying to make this so that people see it. So I want you attorneys to understand where I'm coming from when I do this. And if it doesn't work out and you have more questions, we'll continue to make it better. But in the end, this is, I think, part of preserving the system. What we love to do, what we love to be in court and fight for our clients, the state, what you do to bring justice to the community, the defense, what you do to protect people's rights, they will see that. And I think once they see it, they will have the confidence to believe in the system like you all know they should. So it will be on. You know, the other thing is it allows people to see what happened. There is a suggestion that last week cameras were secreted. That was the word. This is where it sat last week, right here. There's a picture on the internet of some little pinhole in a wall, makes it look like no one saw it. It was right here last week. Let people see that. It's all open. This week, though, so it's not so in your face, we've made an adjustment. It's right here. I want you all to know where it is. All right, so let's go forward. We will be transparent. I thank you, state, and I thank you, attorneys, for being here. I wanted y'all to understand why we are doing this. Transparency is simply it. Yes.
May I inquire as to one relevant question?
Yes.
We need to confer with our clients. I understand what the court is trying to do. What I'm asking is, are those the only two cameras? Are there other cameras? What I don't want to do is step over here with my client, have a conference, and inadvertently miss the camera. I understand the cameras are readily visible, but for the benefit of justice, which I think you're promoting, can we know the location of the cameras and mics being utilized?
Yes, absolutely you can. You can know everything about this. That's why, for instance, on the screen now, I've put it up there so that there can be no doubt. There is, for today, there is the camera here on the court. There is this camera right there. Now, there's always a camera in this courtroom that is running. It's in the back corner. You can go and watch it anytime. And there are microphones that are used at times by the court reporter. And she records. So there's nothing different in that sense. But the only ones that today we have, and it's fair for you to ask, are where they are located. And they're this one right here and the one on the back of the, here on the box.
And thank you for letting us know. The only other at issue, which is a lethal hope that every criminal defense attorney has, have you considered the implications for if a person is acquitted and they seek an expunction? Is the broadcast going to be something that would be subject to expungement, or is that something that would remain? I don't know the answer to that, but I would think that would be a relevant issue for the court to consider in the future.
I agree. I've already considered it. I mean, I've really thought of this a lot. It didn't just come into it because I want to protect these people's rights. That's what my job is here, and I try to do it all the time, and I think you all see it. Here's what I know. They do this in a lot of other counties. They run them full-time all the time. I'm not planning to do that because there's a lot of, you know, we have both civil and criminal. There are different statutes that apply to civil. For instance, it was put out, there was a suggestion that there is required consent. That's in the civil code. That's not in the criminal code. That wasn't correct. So there are different implications of this, and we'll look at it. But I know that they're doing it, for instance, in a lot of other counties. I'm talking to them. I also talk, none of this is done without the authorization of the Texas Office of Court Administration. They set it all up. They give the Zoom. In fact, you can go to their webpage and see all of those other courts that are live. And they've dealt with those things too, and we will too. We're not overlooking them for any purpose other than transparency. And, you know, last week when the state came to us and the state said, look, there's this issue of a child witness. And in the code, Article 58-105 says that no one can use the name of the victim, right? But the code says you can't do it at all. But one of the parties last week said, we don't think we can comply with that. We think that that victim's name will be used, even though the law says unequivocally, you cannot use it in any proceedings. And so I shut it down before we ever went any farther because I was told that one group couldn't comply with that law. So we're going to follow the laws in here. And even if it means at some point that we have to shut it down because we need to provide more protections, we'll do that too.
If at some point, and forgive me for speaking on this issue, the camera positions change, I would merely ask as a participant of your courtroom, participating as a criminal defense attorney, that we be advised, because we're not always the sharpest tool in the shed. And sometimes you just got to point it out. That way we can protect our clients' rights, due process, and respect the court.
Yeah, I want you to be able to. I mean, if we do a trial in the future, it's going to be the same setup here. And then there will also be one on the witness stand, similar to how I've seen other courts doing it around the state. And we'll make that so where it's not obtrusive on the witness. But realize right now, I want to give notice, that's where that one will be. There's not going to be any others in any other part of the room. If that changes, I will let you know.
Thank you for letting me ask these questions. And that's it.
Okay, very good. Let's move to the docket. I know you all are here and ready to get going, and I appreciate you taking a moment to understand why we are doing this. So defendants, if you are here, if you would, please rise just so that we can identify you. And attorneys, if you have a quick announcement, please do that. I've heard from your colleagues. Sometimes they go longer, and if we need to approach on something longer, we'll do that. We've been doing this for a while. All right, Samuel Areola. Joe Cappuccino. Rosalie Cortez. I will. I'll mark you as confirmed. Thank you. Josue Crespin Efegenio. Thank you, sir. Sir, do you have an attorney?
No.
Do you expect to get an attorney, or would you like one appointed? I'm sorry? Okay, then we'll approach and discuss it. Michael De Los Santos.
Judge, we're here, we're ready. I'm in jury trial. If we get that reached as soon as possible, I would appreciate it.
We'll do you that one first.
Thank you, Judge.
Kimberly Destin. Thank you. Do you have an attorney? Okay, we're going to approach and discuss it. Morgan Dickerson. Thank you, Mr. Dickerson. Luis Angel.
He's present with counsel, Judge. I already accepted the review or reset. I could approach after Docket.
Okay, yes, please approach. Francisco Flores.
Present with counsel, Judge. We're conferring with the state.
Very good. I will mark you conferring. Selena Gonzalez. Anya Hart. Mark Herrera.
Yeah, no, and Judge, we're conferring. If you could place on recall, please.
I will. Thank you very much. Eric Jimenez.
Judge Malik said he's running a little late. He'll be here directly.
Okay, please let us know. Patrick Jones. Mr. Jones, are you here? All right, I've signed the waiver on that one. Joshua King.
John, can we approach?
Yes, let's do it. We'll do Mr. Jones first because he's in trial.
After the doctor.
Amanda Maureen.
Present, Brown.
Thank you. Do you have an attorney?
No, sir. We're going to discuss it about it. Also, we need an appointed one or also more time for the table.
Do you want one appointed?
Yes, please.
Okay, what I want you to do is when we get done here, the bailiff will let you know where to go downstairs so you can put it in an application.
Makes sense.
All right. If anyone else who we've spoke about before that doesn't have an attorney wants to put it in an application, see the bailiff and he'll let you know where to go. Gilbert Maureen.
President Council Judge, we have an agreed reset for the purpose of giving the state some litigation information.
Okay, let's approach on it. Jose Palacios. Thank you, sir. Oscar Pastrana.
Your Honor, this was in TDC. He was in TDC. I don't know if they bench warrant him or follow the bench. Do you know if he's downstairs?
Been there for 36 days.
He's downstairs? Could you put us on recall, please?
Yes, I will. Do you want to go down there? Or do you want us to bring him up?
No, we go down.
Okay, very well. Jody Perales.
Your Honor, he is in custody, but I don't recall.
I will. Thank you. Nathaniel Ramirez.
President Council Judge,
Good timing.
requested,
Like burst through the doors.
reset judge, I believe it's our first trial.
Okay, we'll approach. Jasmine Richard. Andrew Serrano. Andrew Taylor. Paul Tomkins.
He's present with council, Judge. Can you fix that on recall?
I will. Have you been downstairs today already, Mr. Tompkins?
No.
Will you go take care of that for me? Thank you. Is it going to be good?
Good.
Good. You look good.
Thank you.
You feel good?
Oh,
Good for you. Brandon Vasquez. Thank you, sir. Is anyone here on Brandon Vasquez? Reynaldo Villanueva.
He's present with council, Your Honor, we're requesting a brief reset to continue with discovery compliance.
Okay, let's approach and see what's maybe missing. Thank you. Junwal Walker.
Judge, we're present ready for sentencing if we can pick that up after Mr. Jones.
Okay. Esnedi Yepes Pacheco.
Recall, please.
I will. Thank you, Mr. Darwin. All right, now we're on announcements for jury trial next Monday. Jacob Kryer. I'll mark you conferring. Lazaro Gonzalez Espinoza.
President Judge, we are turning in paperwork as we speak.
Thank you. Lincoln Pearson.
I'm present on that one, Judge. We're conferring.
Very good. Roberto Rangel. State.
State's ready, Your Honor.
How long do you think you need to try this case? On your guilt innocence?
2 days plus 4 hours.
Thank you.
Judge, Mr. Robinson is announcing not ready. He was just given discovery on Friday, I believe, and he will not be present today. He's stuck in an airport.
Okay, we'll take it up. Carlos, thank you. Carlos Rubin,
We have present, Your Honor.
and your attorney was just here. There he is.
Judge, this is Rubio, is that correct? Or-
I'm sorry, Rubio. I misread that. Pardon
We
me.
have a plea and we're ready to take that whenever you have a chance.
Very good. Joy Smith.
State has a motion to dismiss on that one, Judge.
Okay, we'll approach on that. Stacy Smith. State.
State's ready.
I thought my change this morning. I have a copy of the not accepted already.
Okay, let's take it up
Now,
at the bench. No, let me get through a few of these. I'll try not to waste your time and get through things. And Mario Stafford.
State's ready. Governor defense is ready.
State, how long do you think you need?
Probably 2 days plus 4 hours as well.
Defense?
I said it's about accurate.
Okay. Judge or jury for punishment?
My client and I are still confirmed that it's right.
Can you okay. If you could let us know, that'd be good, and allow y'all to confer further, and we'll come up. All right. Thank you very much. All right, everyone, you may begin to confer, and we'll take up these matters. Your client's name?
De Los Santos, Your Honor.
De Los Santos. So, where did you pick a jury?
And come out with Judge Boyer.
You're down there. What time do you start?
Sometime between 12 and 1. Prosecutor speaking at a conference in San Antonio in the morning, and Judge Boyer was nice enough to let her do that, so we're gonna start up. It's an evading and criminal mischief, so it should be relatively short, but.
Do you have that one? Good. Court call CR 22-0785C, the state of Texas versus Michael De Los Santos III. Can counsel please make their announcements for the record?
Allison Boost for the state.
Richard Jones for the defense.
And are you the same Michael De Los Santos who in CR 22-0785C is charged with driving while intoxicated, third or more offense?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, or nothing but the truth?
Yes.
All right, you previously pleaded guilty to this charge, is that right?
Yes.
And today we're here for your sentencing. I have received a pre-sentence investigation report from probation. Counsel, have you had the opportunity to review that report and discuss it with your client?
I have, Your Honor.
Are there any modifications or corrections?
No, sir.
Is there any legal reason we can't proceed to sentencing at this time?
Not from the defense, Your Honor.
None
State,
from the state.
any argument from the state?
No, Your Honor.
From the defense?
No, sir.
All right, sir. Having found that there was sufficient evidence to substantiate your guilt and having found the plea enhancement true, the court now sentences you to 10 years in the Texas Department of Criminal Justice. That will be suspended for 10 years. There will be 30 days jail as a condition of community supervision. There's a $2,000 fines. The testing you must pay. Is there any restitution from the crash?
I don't believe so, Judge, but I'll double check.
Very good. It's required that you do the VIP live class and you will have interlock on any vehicle. Are you driving a vehicle right now?
No,
How are you getting around?
my parents,
Okay, do you have a job?
no, not yet.
Okay, how are you going to be getting to probation and to your job or to job interviews?
My girlfriend and my parents as well.
Okay, so you're gonna rely on them
Mhm.
this whole time?
Yes.
Okay, well, you understand that if you are driving any vehicle, you must put that interlock
Yes.
device on the
Yes, sir,
vehicle,
I understand.
okay?
I
and
think
if
part of the issue, Judge, was that since he was anticipating doing the jail, he wanted to wait to really actively look for a job until after that. And then plus, we have the recommendation for inpatient treatment. So we knew that was a likelihood, and that's why he hadn't gotten a job yet, because he didn't want to start for a week or two and then wind up going in and having a problem that way, Judge.
Okay, well, that makes sense.
Mhm.
So you're prepared for that to
Yes.
begin that process today?
Yes.
All right, very good. You will do the substance abuse felony punishment facility. You will be on the specialized caseload for substance abuse. Community service restitution is required. You will do your analysis. You must pay the restitution. And I was asking, State, did you know what restitution ended up being?
We don't have any restitution amount for the accident, Judge.
Very good. You'll do the DWI intervention program. After you complete the inpatient, you will do supportive aftercare. And the last thing that we'll have you do is NA and AA meetings. You have 10 years now of probation. That program is one of the very best that we know that will help you. Have you ever been to it?
Yes.
You have?
Mhm.
Are you going to one now?
No.
Okay, well, when you get back, we know that the most effective thing is when you're doing it 3 times per week. So you'll do it 3 times per week. Do you have a sponsor?
Not yet.
All right, we got to get that started. But this is something that I hope that you will really take advantage of. It is something, I mean, here we are in a felony court on this charge. That NA and AA program will talk about those things. And when you have your triggers, you'll have someone who you can call. And so I hope that that is something to help you be more
Yes.
positive in
I
the
will
future.
utilize that.
All right. Is there anything else we need to take up?
Nothing additional from the state.
Not from the defense, Your Honor.
All right, Mr. De Los Santos, I have followed your plea bargain agreement, and because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification and adding that to your file. I must also let you know that because this is a felony, you are ineligible to possess a firearm or ammunition. Understood?
Understood.
All right, good luck to you, sir.
Mr. Gillis,
can take it.
Maybe
right
excuse
thumb
me.
Yes,
straight up,
thank you for
straight
being
down,
here.
and then
No
straight
problem,
up,
sir.
straight
Good
down in
luck
the
in your
box.
try.
Thank you. I'm gonna check in with probation and they'll tell you when. Okay.
He's gonna take it to custody today, right? For
Yes.
safety?
Yes.
Yes, sir. Okay. Thank you.
All right, good luck to you, sir. Thank you, State.
And Judge, I do have that dismissal on Joy Smith. We sent an investigator to locate the complainant and have been unsuccessful.
Thank you very much. Mr. Darwin, on 23/24/57, I've signed the dismissal.
Thank you.
Is your client here?
She's not here.
Okay,
I can probably get her here. But
that's okay. She doesn't need to be here anymore.
We're not gonna move for bond forfeiture.
All right,
Judge, we're ready on Junwal Walker.
Mr. Walker, can you approach, please? I'm sorry. Is that? Actually, that doesn't say the
Mr. Walker, while I have you up here, could I please borrow your right thumb, straight up, straight down on the ink, and then straight up, straight down in the box. You don't need to roll it, just straight up, straight down.
So yes, he needs to do that, but
You don't get that on.
that doesn't need to hold him up before we can start at the program. I don't know if that suggests that. If we need to, let's talk about it.
Okay.
But you understand what I mean? Like,
Yes.
he doesn't have to do 30 days and
And
then begin the program. He can begin the program as soon as he's available.
Okay.
So I just want to make sure that we have the right language, that the jail doesn't think that we're holding him. And he can't start rehab, because that's what we really want to get. And we'll discuss it.
Okay.
Do you have Ms. Walker? How are you, sir?
All right.
Okay today? Yeah. Are you under any substances right now?
No.
Okay. We sent you down to get tested. Would you be clean?
Probably.
Okay. I want to make sure that you're able to voluntarily enter into these questions that I'm going to ask. I'm going to ask that you go downstairs and take a test.
Judge, if I may,
Yes.
I understand why you're inquiring as to that. Mr. Walker frankly doesn't like the idea of being placed on probation, so he's not hesitant and not happy about it. However, given the alternative of the state jail rec, he's going to accept his probation offer. So it's not that his mind is altered, it's his begrudgingly wanting to enter into this probation.
Am I only about me being clean? I stopped smoking. I thought THCA was legal. And that was the only reason, but I haven't been.
So the way he's answering your questions, is it because his mind is altered or he's under any intoxicants? It's more of his hesitation about this probation.
I understand. I just want to be sure now at this point. And I have to know that he's voluntarily doing what we're doing today, and that he can consent because he's not under some. And if you're going to be clean, then it won't be a problem. We'll put you right back in line. I know you've been here a while. So she'll set that up for you to go downstairs. You're telling me you're going to be clean. Is that right?
I'm just, I haven't been smoking. I don't know. I heard that it takes 45 days to 2 months for marijuana. Anything other, I would be clean for.
Well, when was the last time you used?
It was probably about 2 months ago.
Okay, so it won't be still in your system. You and I share the wonderful quality. It's not going to be in our hair, right?
Right.
So you, it's in your system for 30 days, according to the pharmacological studies. So if it was two months ago, then you should be clean. All right.
And Your Honor, he was positive for marijuana at the PSI as well.
Okay, well, let's just get one for today.
Of course.
All right, we'll move you up to the front of the line. Right, if you take care of that and come back after you're done.
I'll let them know that you're coming down, just come down to correction.
All right, Mr. Campbell.
Yes, sir. Gilbert Moran.
Mr. Marin. And we are appreciative for what you do on behalf of clients and taking these cases. How are you doing today, sir? Good. Okay, so I see we're still here. What's the status of this case?
Judge, the state's offered probation. We're inclined to take it. We're trying to tweak the terms a little bit, and the state has suggested that we provide it with a good guy packet.
Okay.
Which we're willing to do. So we'd like to have a reset. In the meantime, we'll furnish that to the state and probably resolve this on the next setting.
Okay, very good. Let's move it to a plea setting then.
Okay.
And that does not mean you have to plea, sir, but if there's not some resolution, I want you to understand the timeline. Your next setting would be in 30 days after that, and that would be a trial setting. Okay? All right, very well.
Thank you.
After you get your reset, you're free to go about your business.
Thank you. Just wait for me outside.
Hello, Mr. Courtney, how are you? Yes, your client.
Villanueva, Reynaldo Villanueva.
Mr. Villanueva, can you approach, please? So the last time I was here, we discussed that you couldn't access a link, but then you checked and you came back later and found out you can access that link.
Well, they renewed the link.
Okay. Well, no,
And
I'm not saying that it
and I
was.
confirmed that I could get it, and I did. I downloaded all the available information.
Okay. Is there anything else that you were missing?
Yes,
What's that?
hence the problem. I don't exactly know what I'm missing. I know that I am missing things. I don't know what it is. I've talked to the prosecutor. He agrees. There's another, he has confirmed there apparently is another file that contains something that has not been put in the, whatever that system is that was on that original link. I've also sent an email specifically
Who's
detailed.
the prosecutor you're working with?
Philip's going to be handling this case,
Okay,
Judge, but he just took it over today.
So I sent an email to him last week about why I think there are additional things, because there are things, there are documents referred to and captured on video that were handed to the detective that aren't in the disclosure. So he was going to be looking into that to make those disclosures and determine where those are. He additionally.
When did you reach out to the state with those issues?
Last week or two.
Okay. And state, have you taken any steps to try to figure out what's going on?
Judge, I believe Philip looked into it and found that there was information from another case that just needed to be added to the evidence.com link. We should be able to do that fairly quickly, but I'm not sure if that's going to be everything that Mr. Courtney wants. So if there's anything additional that's not included.
I guess I gotta back up a little bit. It's not incumbent upon me to say I don't have X, Y, Z.
Quiet, please.
If I knew what it was, I'd probably have it. So I'm just saying, I know there are items. I'm pointing to why I know why I believe that, because they're on a video that they've disclosed. If I were to hand you my glasses, it's on there, but the glasses aren't in the packet. And so I basically said, I believe that the detective must have these documents somewhere. Would you look into it? And they've said yes, and they're looking into it. I believe they are.
So what's the timeline to get those answers, State? We've indicted back in December of 2023, so it's been almost 7 full months. It's been 7 full months, and not knowing where the evidence is a concern. or what is all the evidence is a concern, he should have that evidence at this point.
Yes, sir. And we should be able to add that to the evidence.com link within the next day or two. My only concern is if there's still anything that's outstanding, if you let us know as soon as possible so we can start working on it. And now you know Philip's handling it, so you should contact them.
And that's what we've been doing.
Okay, last time we were here, I said that we set up a timeline of moving to from pre-trial this time to next setting would be a plea setting. But due to the state not having given you information, are you ready to go to a plea setting?
I don't think I'm prepared to go to a plea
Okay,
setting
the answer
without,
is either you are or you aren't. And if you are asking for another pre-trial setting, I'm gonna give it to you.
I'm asking for another pretrial setting to complete this. Yes.
Done. Okay. All right. So I told you a timeline. I know this is weighing on you and you have a right to a speedy trial, but if y'all need more time in order to find out more evidence, then you will get it. Understood?
Yes, sir.
All right.
Thank you.
I think the next one then, as I told you last time, I think this will be the next pretrial setting. After that, we would move to a plea setting.
Yes.
All right. State, let's make sure that you're getting all the evidence in a case. Whether the attorney asks for it or not, you are doing the diligence to get that to them.
Yes, sir.
Thank you. All right.
Maybe excuse?
You may. Thank you. Hello. How are you doing, Judge Brown? Judge Brown, Miss Brown.
I'm here on CR 23-2132-A, Stacy Smith, jury announcements.
Okay.
I don't know if things
I
came
haven't had
through
an
or
opportunity to
not.
review this. Can I have a moment?
Yes. We lost power last night, so I was at the clock this morning.
Ooh.
Oops. Very close.
Did it blow the transformer?
Around the corner, and the dogs up this morning at 6 and they're still in the lab. We were back up. Yeah.
So what is the new evidence that the state handed over? By the way, is the defendant here?
No.
I think this scheduled date is July 30th.
He's in Burke County, Your Honor.
Okay.
He was arrested Friday.
And do we know why he was arrested?
I believe it was a combination of the bond violations as well as some additional warrants that Officer Server obtained for violation of protective order by committing assault, as well as retaliation and witness tampering.
Okay.
I printed out.
So he's unavailable to be here.
Yeah. Or to assist in his defense. I'm not driving to San Antonio every day to read trials.
Okay. Well, I also understand that he's going to be here sooner.
Like, gives me 2 days that you're ready for a trial.
Well, I mean, part of it is he is the one who has made himself unavailable. I mean, is it not correct that he cut his
I don't know.
GPS tracker?
I haven't seen the memo violations. I didn't get notice of that. Twice before it's been happening where he had a bond violation. It was filed in the court record. I got a copy of my discovery the next day. I still haven't received any of that. I didn't even know about it. So I got a call Friday night frantic that he was being arrested. And I'm trying to research on my phone while I'm walking around a shopping mall, figuring out what the heck happened, because I guess he got indicted on Wednesday last week. And then an order for keepies was issued on Friday, was what I saw. And then there was a bond violation as well. So I had to tell him, I don't know why I got arrested. One of the two reasons. Maybe he got, I didn't know it was something for San Antonio, but I assumed it was us. So anyhow, I was completely out of the loop, and also led to believe, if you read my motion, up until Ms. Buse took over the case, we've been negotiating on a plea, which wasn't satisfactory to my client. I didn't put in the terms of it just so the court wouldn't know those terms, but it was increasing as my client continued to delay any acceptance of it, as I would expect. And then on the 5th of July, after I completed the trial, I emailed the state prosecutor, then it was Abigail Whitaker. She wasn't in court at the time of the guilty plea setting, so I couldn't discuss things with her. And her folks that were in here didn't have any authority to talk to me about anything different about the plea. I emailed her that day, told her I wanted to talk to her more about it. It's all in my motion here, and I didn't hear from her till the 5th of July, wherein she said, well, do X number or whatever, and he has to do it on the date of jury announcements. So that was kind of the mode we were in. And then Ms. Buse took over the case on the, maybe sooner, but she let me know on the 10th via text that she was taking the case over and that she was going to do all kinds of other things. And then asked me if I had seen this data. I'm like, no, it was apparently generated in 2023. And it's kind of important considering it's evading arrest in a vehicle. Identity is an issue, and it's all cell phone data. And I don't even get the underlying data because there's a suspicion that there's child porn on the data offload of my guy's phone. So I mean, like, it's just a mess. And I never even had that. I've been on the case since October, substituted in 2023, October 2023. No subpoenas had been issued yet by the state. As of my conversation with her yesterday afternoon. So she kindly sent me their application for subpoena they filed yesterday. Now I have to subpoena people they didn't, because I wasn't expecting to go to trial because we were working on a deal. And then I also discussed the fact there's Brady violations potentially. And so they hustled and got me some notes from some conversations with this alleged victim who's all over the place. And she comes in all the time and says there's different versions of what happened. And this was produced yesterday, no date on it. I made the assumption it was from back in the fall when she did a non-prosecution affidavit. So there's a lot of problems, a lot of late disclosures. And it's only because Ms. Buse took over the case and she was going through it and doing what she's supposed to do. You know, do you have this, Vicky? Do you have that? Do you have that? I'm like, no, I don't have any of this stuff. But on June 25th, I made them know there is Brady information y'all haven't given me. And I just got this yesterday. I mean, it's just stuff
Who
like
did you
that.
let know?
Ms. Whitaker, the previous ADA. Well, and then Allie, I probably saw my email or just looked on her own, but she ended up getting, she was trying to cure it yesterday. Allie was the new prosecutor.
And Judge, specifically what I had disclosed was that the complainant had come into the DA's office and had conversations with 2 separate prosecutors. That information was shared with defense counsel, but it wasn't documented. The information that the complainant came in and provided is similar to information that she's provided to law enforcement that's documented both in the San Marcos Police Department report that's been turned over, as well as the New Braunfels Police Department, which has been turned over, and is also consistent with the non-prosecution affidavit, which was previously turned over as well. So it's not new information, it's just consistently bad information. And obviously that could potentially be used to impeach her if she were called to testify. I can tell you, I have not subpoenaed her. I do not intend to call her to testify simply because ethically, I don't believe I can put her on the stand if I anticipate that she's going to lie, which at this point is what I would anticipate. So
she's the victim.
So first, here's the thing, we can't make any decision today without him here. But what I'm trying, the reason I'm listening is because I want to hear you out, but I also want to give you an idea of what we are looking at doing, so you know if you need to continue to prepare.
Mm-hmm.
I think he will be here in the next few days. I want to reset this case for then. In the meantime, I think you need to work under the assumption that we will be going to trial on his case. If he's in custody, the code requires me to put him to trial first. So which case would you want to go on if we do go to trial?
I would ask the court to clarify whether we would be going on the superseding indictment or not.
He hasn't been arraigned on those charges yet. There's a new charge of aggravated kidnapping with a deadly weapon and amendment of the other charges to add deadly weapon.
And in the event that the court says that we would have to go on the old indictment, I am prepared still to do that. I would go on the evading motor vehicle charge only, and I would file notice of intent to seek a deadly weapon, which was what was alleged in the new indictment that would affect the evading charge.
That I received yesterday, only because I asked for it.
Okay, well, I think let's get him here and the court will be open. I'll have Becky contact you when we know that he'll be here, and we'll come in and take these up in front of him, and he has the right to be present for all these important discussions and decisions, including whether a motion for continuance is granted or denied. So I think expect that, but I ask you both to continue to prepare, especially considering this is one of someone who is in custody, and be thinking that you will be going to trial on Monday until we have him here and we can do the motion for continuance in full.
Okay, and what about the 10-day objection?
Well, it sounds like she's just said she would go on the old indictment.
That's what I need to know. I need to know what you're ordering we will be going on, because I mean, on Monday, we wouldn't want to comply with statute.
It would be the evading motor vehicle charge from the original indictment. And I will be filing a notice of intent to seek deadly weapon in conjunction with that offense.
And that doesn't remedy my problem of just getting the geo time report on the 10th. This is July 10th. I received that and looked at it the following week. There was a previous attorney, and I think there's a mistaken belief, like having told defense counsel of this quote in whatever statements were given. I think a lot of that was done with the other attorney and not me.
Were you on, is this related to the evidence for evading?
Yes.
And were you on the evading case?
What do you mean was I on the evading case?
Were you the attorney of record?
Back in October, I subbed in for previous counsel.
Okay.
Correct. And there was new information that was provided, including an update to the, or supplement to the offense report, which detailed the mapping that was done and the findings from the mapping. I don't think the actual maps themselves have been turned over, but the maps themselves are actually, they're marked as drafts. They're not the final. Typically, our analyst doesn't produce the final until the case is actually going to trial. So I will coordinate with Ms. Holmes to make sure that that is finalized and turned over to defense counsel. And I will also see about providing the underlying call detail records, because that's separate from the forensic download of the phone.
I have a right to see the download of the phone. I mean, I have a right to have an expert look at this. They're only giving me what information they think I want or need. And I get it all. They can't just give me what they want. And now there's claiming there's child porn on it. I'm like, well, are you going to use anything from this phone? Or are you not? I mean, it's just little things to keep here. And we found this, and we found this, and we found this. I mean, like I put in my motions, there's been more work done on this case in the last 12 days than there has since his arrest, since Ms. Buse took over.
Okay. Well, we'll let you know.
Okay.
As soon as possible. I understand that he will be here soon, and then we'll take it up.
Okay, who's getting it? Like I was fully not coming to the 30th.
I've understood from one of the transports he's going to be here even sooner. So let's look, when we find out more information.
Okay.
Or if you find out more information, if any of us do, need to continue to confer.
And I also have 5 juvenile settings on Monday morning.
5 what settings?
Juvenile settings over in East County that had to be continued because of the case that ended up going the first week of July. And those typically do take precedence over other matters because the juveniles' ages. They age out and they can't be subject to the court after a while.
Well, I don't know if they'll take precedence over someone who's in custody. Under the code puts custody defendants before others.
Maybe we can just accommodate and have a recess after we select the jury or something, so I can handle them in the afternoon. Just
Okay,
something to consider, Judge.
We can discuss accommodations.
Okay. It's just I keep bumping them because of these jury trials, and these juveniles need to get resolved.
And
I agree.
Vicki, if you want to see the forensic download of the phone, just let me know when you want to do that, and I'll coordinate with SMPD so that you can view it at SMPD. I can't give you a copy because of the CP that was located on the device, but
Okay, y'all continue to
Thank you,
confer.
Judge.
Doesn't need to be here, and we have to do this anyway with all of the defendant present.
Okay.
All right, what do you want me to do?
I need to get him downstairs.
Okay, what's the question?
Is that okay? As read?
Yeah, you can have that work. Once you do that, you can send it down. Okay, are you a quick one? Let's just get one of these and then we'll do Walker next. Walker, come on up, stand at the bar. Go. You, come.
Oh, I'm sorry.
Yeah. I was gonna give you, you're gonna get one done real quick. What is it?
Lewis Engel, E-N-G-E-L.
Engel, can you please approach? ENGEL.
Your name, ma'am?
Kelly, Kellie. Fox.
234404. All right, we're here on a pretrial setting. The last time we came, we said this would be our last pretrial setting, and then we moved to a plea. You have an offer. Is there anything else you need to take up this time?
So we do have an offer. The last time we were here, we subbed in, and we've just had many attorneys at our firm be out and sick. So we've requested discovery as of yesterday. So that's on us for delaying that process a little bit, but we don't have the discovery yet. In addition, we're working on the good guy packet for the state. If we could just get one more pretrial setting just to get that discovery.
So on May 23rd, I had new attorney takes over, and we discussed at the bench that it would not be used as a delay. And you're telling me that just last week you were able to get discovery?
Yes, and that's just because my assistant as well as other attorneys at the firm have been out and we're just a little backlogged.
Okay, well, we'll get 30 days. We're not going to go to trial in 30 days, but it will be a plea setting. Doesn't mean you have to plea, but if there's not a resolution, the setting after that would be a trial setting. That's still all 60 days away. But that way you understand what the schedule is and what you're facing. Fair enough? Okay. All right. Thank you very much.
And counsel, I did ask our discovery management person to move that to the final line, so you should get it today.
All right, Mr. Walker, let's take care of. The results.
We do.
Mr. Walker, good for you. Court calls CR 23-5068F, the state of Texas versus Junwal Walker. How do you say your first name? Junwal. I apologize. I want to get it right. Can counsel please make their announcements for the record?
Allison Boost for the state.
Mark Chavez for Mr. Walker.
And are you the same Mr. Walker who pleaded guilty in CR 23-5068F to theft, to prior theft convictions?
Yes.
We're here today for your punishment hearing. I have received a pre-sentence investigation report from the state. Have you had the opportunity to review that report and discuss it with your client?
Yes, Your Honor, we have reviewed it, including the recommendations.
Are there any modifications or corrections to the contents?
No, Your Honor.
Is there any legal reason we can't proceed to sentencing at this time?
Not from defense.
None from the state.
Any argument from the state?
No, Your Honor.
Defense?
No, Your Honor, we have a simple request. If you see there in the PSI, he is doing what he can to pay child support, including arrears to obviously make it right. We'd ask the court if you'd be open to doing a financial study to lower his probation fees so that whatever extra monies he has extra can be focused on child support.
Do you have a job, sir?
Yes, sir.
What's your job?
I'm a construction inspector
And where do you do that work?
in Macon, Georgia right now.
Okay. All right, well, go and speak to the indigent coordinator downstairs and let them know what the amounts you're making. If it's an amount that is below the threshold, then we can do that. Otherwise, you'll still have to pay what is required of anyone who makes a salary above that threshold. Understood?
Yes, sir.
Your Honor, are we doing a indigent study for probation fees or for court fees?
I mean, it can be for all of it.
Okay.
I mean, if the idea is that he can't pay because I want him to pay, how much do you have to pay per month? Raise your right hand for him. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
Yes, 360 something, it's 360 a month.
Okay. And how much are you making at your job?
Roughly, I would say $18 an hour.
Okay, well, how much is that working out to per week or per month?
Per week, it's about, I get paid every 2 weeks, so I bring home probably $1,500.
Okay. All right, well, they'll fill that all out. And you can take a look at that point and we'll make those decisions. For now, is there any legal reason we can't proceed
No,
to
sir.
sentencing? Argument from the state?
Nothing
After that?
additional.
No.
All right. Having found there was sufficient evidence to substantiate your guilt, the court now sentences you to 2 years in the state jail facility that will be suspended for 5 years. There's a $500 fine, court costs which are due today. State, is there any restitution due?
No, Your Honor, the phone was recovered.
Very good. You have the supervision fee. You will do 200 hours of community service restitution. In addition, you will do UAs, the cognitive education program, DAMP, and an apology letter to the victim. Do you understand those conditions?
Yes, sir.
All right, sir. I have followed your plea bargain agreement. Because I've followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification that says the same. That will be added to your file. Is there anything else we need to take up?
Nothing from the state.
Not from the bench. Your Honor.
All right, good luck to you, sir.
Thank you, Judge.
Thank you. All right, who do you have?
Hi, Francisco Flores on your pretrial docket. He's on page 3, Judge.
Francisco. Page 3.
Yes,
Flores?
Judge.
Mr.
Yes.
Flores, can you approach, please? All right, sir, how are you today?
How are you doing, sir?
Good, we're on a pretrial setting. Defense, do you have discovery?
We don't have everything, Judge. There was just a subpoena sent out from the state this morning about an hour and a half ago for CPS records. We are still missing witness statements, and we believe we're missing medical records as well.
State, what's the status?
Judge, this case was just assigned to a new prosecutor who's going to be handling it. She has been looking into it. Going through the file, she noticed that we did not have CPS records, so she is making efforts to get the additional information that is needed. I don't have a timeline for CPS because they're CPS, but we are going to do everything we can to make sure that we get that as soon as possible to defense counsel.
So it's been over a year since the state indicted this case. Very serious first-degree charge. And when the state does that, do they not request medical records and CPS records at the time, or make statements available to the defense at or about the time of indicting someone for a charge like this?
It's not unusual, given the serious nature of the charge, that a case sometimes is indicted when those things have been requested but not necessarily received. And
But what I'm
unfortunately,
understanding is that the CPS records had not been requested and the medical records had not been requested until this morning.
This morning, they were subbed by the state. We have the forensic interview, and we need to watch that interview. However, normally it's coupled with a non-acute forensic, non-acute examination, which we don't have records of right now.
and I'm not entirely sure, Judge, because it's not my case, whether one was actually done. I know that's common practice, but it's not done in every case. I know Elizabeth is looking into that.
Is there someone from the state who can answer those questions? And if they are, let's get them here. I mean, we're a year in on a first-degree felony where there's a child under the age of 14. We need to be moving forward, but we can't move forward because what I'm hearing is someone else, not you, hasn't done basic discovery on critical issues. So if you wait, step back.
Yes, Judge.
Let's bring someone who knows the answers to those questions and start moving forward. Because again, indicted July 23 with a November 2020 date. This is the problem of us not moving them forward, is issues like this. So let's talk more about it. Please state, let's find the person who can answer those questions.
Thank you, Judge.
All right, I'm gonna step back. Mr. Darwin, how are you?
Good.
What do you have?
Off your pretrial docket, I have Ms. Yepes Pacheco.
Con Y?
Pardon?
Con Y? The letter of her name.
Oh, yes.
Yes.
What? What do you say?
With a Y. All right. Hello, Ms. Yepes Pacheco. All right. We're here on a plea setting. What is our status?
We just need to take her down to misdemeanor court. We worked out the deal down there.
Okay, very good. We're gonna move this to a trial setting, so you have 30 days to get it taken care of. Can I get it taken care of?
That's
during
true.
that
Thanks,
time?
Judge.
All right.
That'd
Well,
be
if you, if not, we will be set for trial if it's not taken care of, but I expect all the parties here will do it.
We'll do it.
All right, thank you very much. Thank you, ma'am. Have a good day.
And then,
Make that a trial setting, please.
then I have Jacob Kryer off the jury docket.
Mr. Kreitzer, can you approach, please? Morning, sir. We're here on time. Thank you very much. What's our status?
I'm ready. The only issue I have is that I do have conflicts on Tuesday and Thursday with federal court. I mean, I anticipate we probably could get it all done by Wednesday. The trial, that's kind of, I'd go to you for punishment if we get there. So.
Probation eligible?
Yes, no prior felony convictions, right? Yeah, probation eligible.
State.
Judge, state's ready, and I agree with defense that if we pick a jury Monday morning, that we should be able to, even with the conflicts, be done on Wednesday.
Okay, we'll accommodate it. We'll put this in line. There's a case where there's a defendant in custody. We'll see what happens in that one though.
If we do go, I might ask just in case if for Wednesday, maybe if I could get like a second chair, just in case like they're deliberating into Thursday or something like that, but I guess we can cross that bridge.
Okay.
Later, I mean.
Okay, no, we'll accommodate.
All right, thank you.
Thank you very much. We'll see you back here on Monday, sir.
Yes, sir. Thanks.
Good morning, Mr. Mendoza. How are you?
Good, how you doing?
Good.
I have two. First is Mr. Rubio, so I'm child of the judge. We have a plea.
Okay.
And we're ready. We should swear him in, judge, but he's here.
Mr. Rubio, can you approach? In the meantime, let's take up this one while he comes up and you get sworn in.
May I approach, Judge?
Of course. How are you?
I'm doing great. How are you, Judge?
Good. Who do you have?
I have Andrew Serrano on page 5 of the non-jury docket.
Okay.
So
where is he?
He is downstairs.
We need to get him up.
Okay.
I'm sorry.
That's okay.
Whatever
I'll
we
get him
do, we
brought
need to do with him present. So
Okay. I'll get him up.
can we get Serrano
Judge.
up, please? Yes. Who do you have?
Mr. King, Josh King, Your Honor.
Is he here now?
Yes, Your Honor, yes.
Okay. Mr. King, can you approach?
Thank you, Your Honor.
Are we doing something quick on this
That's
one?
going to be pretty quick, Your Honor, yes.
Josh King.
Quiet, please. Thank you, Your Honor.
Is this new to this court?
Judge, it's a quick summary, Judge. This case was set for a trial last month in Judge Steele's court. So it got transferred by Judge Tibby to your court. We currently have an announcement setting of August the 20th and a jury trial setting of August the 26th. The purpose of this pretrial was just to make sure that we had put on the record and asking the state to make sure that they complied with all the 3419 discovery Brady disclosures, Judge. We've pointed out 2 additional officers to the prosecutor on this case, Ms. Hanson. We talked to her about that. So she's going to be looking into that information to make sure that there's nothing that they need to turn over to us. We don't want to put that part of the record. And we've also agreed with Ms. Hanson because we had some issues with regards to the subpoenas being returned and processed by the district clerk. So he's indicating to us that she would be available to let us know when the subpoenas have been served, if they have or have not.
When did you give Ms. Hanson notice that she needed to get you additional information?
Just right now, Judge, we just met in the back room. She came in and we spoke to her, Judge.
Okay. Our next, whenever our next criminal docket is, let's please get a setting there so you can tell me what the status is of the state getting you that information.
We're set for the announcement on the 20th, Judge. So today and the 20th.
Is that the next criminal docket?
We don't have another criminal document until August. Yes, August 20th.
Okay. All right, well then that's the time it'll be. I just wanted to bring back and have the state let us know if they had taken care of that.
And that's the only reason why we wanted, and we get kind of rude earlier, wanting her to be here. That way she's speaking directly to the court, because this prosecutor is not fully aware of what's going on with this case. As you know, she just came into this court. Ms. Hanson took it over, and that's the only reason we were asking her to be here.
And we do have a 3914 database that's available for defense counsel to review by officers. So he's welcome to review that. I understand he's asked specifically that we look into additional officers, and Courtney is going to do that.
And Your Honor, I understand they have the database, and that's great and dandy. However, under the current Court of Criminal Appeals Hanson decision, them having the current database is not necessarily complying with that decision for the Court of Criminal Appeals.
Do you have that case?
I don't have it, but I could get it to you, Judge. It just came out 3 weeks ago.
I'd like to read it. You don't have to get it right now. Just when you swing around the courthouse next time, if you have a paper version, I'd love to.
I have it to you, Judge. It came out maybe 3 weeks ago, Judge, where regards to now the state is them and any law enforcement agency, Judge. So that's the database is great. We like it, but that does not comply with their duty according to the Court of Criminal Appeals, Judge.
Are you talking about Heath?
Heath, I'm sorry, I said the wrong name.
Okay.
Keith, yes, thank you.
Okay.
But I'll still get it to you, Judge.
If that becomes an issue on the 20th, I want to be up to date on that case that you're talking about, and state if there's any other cases you want me to read, please provide those. But we'll see you back on the 20th.
I'll drop it up in the front, Judge.
What's that?
I'll drop out the opinion in the front if you're not in the court.
That'll work. Mr. King,
Yes, sir.
we need you to be here on time. I called quite a bit later.
Judge, he was here, Judge.
Was he?
Yeah, he was sitting back here. I announced and I announced for him, indicating that we were going to be approaching after the first person, and we just been waiting.
I didn't get that you were here. I'm sorry, I missed you.
No problem.
Just want to let you know. The reason is sometimes your attorney can't come forward and take care of these things if you're not here. But if you were, we appreciate it. I apologize.
No,
Have a
sure.
good day.
Thank you.
After you get your reset, you're free to go about your business.
Judge, we already have those settings, so do we need to sign another reset?
Okay.
So we
It's
have-
already set.
Okay, yes,
For
thank you,
the
Judge.
20th.
May we
Right.
be excused?
You may.
Thank you.
What's the setting on that, Becky? Is it, it's an announcement? Okay, very good. All right, we're here on Carlos Rubio.
Yes, Judge.
Are you ready, Ruby?
Yes. Yes, sir.
Court calls CR 233819F, the state of Texas versus Carlos Rubio. Can counsel please make their announcements for the record?
Carlson Boost for the state.
Anthony Mendoza for defense.
And are you the same Carlos Rubio who in CR 233819F is charged with possession of marijuana, 50 pounds or less, but more than 5 pounds?
Yes, Your Honor.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. I have paperwork here that indicates that you would like to enter into a plea agreement on this third-degree felony. State, what is the range of punishment for a third-degree felony?
No less than 2, no more than 10 years in the Texas Department of Corrections, and up to a $10,000 fine.
Do you understand that that is the range of punishment that you face for this charge?
Yes, Your Honor.
I'm showing you what is marked as the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there are a list of rights that you would be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes, Your Honor.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, Your Honor.
And is this your signature on the final page?
Yes, Your Honor.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow the agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding those rights, you still wish to proceed with this plea agreement.
Yes, Your Honor.
Have them slow down just a
Yes, Your Honor.
Are you a citizen of the United States?
Yes.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied that the state fulfilled that obligation?
Yes, Your Honor.
And do you believe that Mr. Rubio is competent to enter into this plea today?
Yes, I believe he's competent.
Mr. Rubio, the reason we talk about the evidence is because you have the right to know what the evidence is against you in a case. Did you discuss that evidence with your attorney?
Yes, Your Honor.
And are you satisfied that your attorney has provided you with effective assistance of counsel during the course of this case?
Yes, Your Honor.
According to your plea bargain agreement, in exchange for your plea of guilty to possession of marijuana, 50 pounds or less, but more than 5 pounds, the state will recommend deferred adjudication for 8 years, a fine, restitution, fee, and evaluation, and community service. Is that your understanding of the agreement?
Yes, Your Honor.
Would you like to enter into that agreement now?
Yes, Your Honor.
To the charge of possession of marijuana, 50 pounds or less, but more than 5 pounds, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
Based on your plea of guilty, based on your judicial confession, I find that there is sufficient evidence to substantiate your guilt. What I'm going to do is order a PSI. Someone from probation will speak to you, make sure that you cooperate with them. After they prepare me a report, we'll come back and do your sentencing at a future date. Understood?
Yes, Your Honor.
All right, thank you very much.
Thank you, Judge. Maybe I have one more, sir.
Okay.
Maybe Mr. Rubio be excused?
Yes. Thank you, Mr. Rubio.
Judge, you prefer to hold the reimbursement order until it actually comes to you with a judgment, is that correct?
Yes.
The other one I have is Mr. Ramirez, Nathaniel Ramirez. It's our first pretrial judge. I'm still going over the case to them, and I'm just gonna work on getting a mitigation packet.
Mr. Ramirez?
Provide with the state. Nathaniel?
Good morning, Mr. Ramirez.
Good morning.
All right, this is the court you will be in. This is a pretrial setting
Quiet,
today.
please.
Just wanted to let you know what's going on in your case. Counsel, do you have discovery?
Yes, Judge.
Do you have an offer?
Yes, we do.
Is there anything else we need to take up?
Not this moment, no, Judge.
All right, thank you very much. After you receive your reset form, you're free to go about your business. Thank you, sir. Good morning, how are you?
Here on Lazaro Gonzalez Espinosa, we're on the trial docket, but entering a plea, Judge.
Are we ready, Mr. Gonzalez Espinoza?
And Judge, can I have just one moment, because the victim had contacted our office and informed us that he initially wanted to be present for this plea. He hasn't arrived yet. I'm just going to have my back call him and see if he still intends to be here, if he's on his way, or what the status is.
Okay.
So if I could just have a moment.
Very good. And given the charge here, and we're going to request a PSI, right?
Yes, sir.
Okay. Very well. If you just step back for a moment.
Does
please
he
let
need
us
to be
know.
here for the plea or just for sentencing?
He's entitled under law to be here for sentencing, but he wished to be present for the plea as well.
We're going to give a moment. I understand you've been waiting, and but let's let her.
No, I understood, Judge, understood. I just, this was not.
No problem. All right, if you just step back for a moment, sir. Who's next?
Hi, Judge.
Hello, how are you?
Good, how are you?
Good, nice to see you.
Me too. We've got two cases.
Okay, first one.
First one is Lincoln Pearson.
Please approach Mr. Pearson.
On your trial docket, Judge.
Yes. Morning, sir.
Our office announced ready for an in-custody murder trial out of Travis County. So did the state on that case today. They were at a docket call just now, and that one is expected to go on Monday. But I did talk to Abby, and we kind of agreed on August 26th would work for both of us, or September 24th, if we're able to move the trial to those dates.
Okay, we're not going to move the trial. We need to be prepared to go to trial on Monday. But if you are in a trial, then you just call and let the court know. But if something happens between now and then, and there's some plea that works out, or the state doesn't decide to move forward on that case, then we would be ready to go.
And so judges, so if you don't remember, when we set it to this date, the defense did let you know they had this preferential murder trial setting in Travis County. And so I'm fine waiting and seeing if it goes, but I guess probably, well, never mind. The other thing is I did just hand this morning a supplemental motion in limine
I have not e-filed it yet, so if you don't mind, I'll file that this morning in court.
Okay. Well, we can take it up before trial if we get there.
Right, we don't need to hear it today, especially since she's not one of the attorneys actually on the case. I just wanted to get it filed. So it would be there.
All right, well, plan to be here, sir, and if your attorneys aren't here because they're in another trial, then we'll just reset it and go about your business.
Sounds good. Thank you.
Okay,
Thank you,
very
Judge.
good, thank you.
And then I have one more, Paul Tomkins.
On this one, state, how many days do you expect to
Oh,
need?
sorry. On the case in chief, Your Honor, I would expect probably 3 days, just like last time.
Defense, judge, or jury?
I'd have to get with Joffrey and Liz on that one,
Okay.
Judge.
Last time it was jury, Your
Please let
Honor.
us know.
I don't know if
Okay.
that's changed, but it was jury previously.
And Judge, just to make sure, Liz and Joffrey will be in Travis County that morning. It's okay if they do not show up here if that trial goes. We'll just reach out to
That's
the
right.
court and let y'all know that
Yeah,
that one's
just
going.
let us know.
Okay.
Okay, but I mean, the idea would be if we already assumed that nothing's gonna happen during this week, y'all could become available. This being one of our cases that is a 2019 offense date and a 2020 indictment date, it is one of the older ones, so we need to all be prepared to go on it.
Understood. I'll let
Okay,
them know.
thank you very much.
Thank you. And then I have Paul Tomkins.
Mr. Tompkins, coming up. You look good.
Thank you.
Feel good?
Mm.
Why you feel so good?
Healthy.
Because you're clean.
I know, right?
Good for you, man. I'm happy for you. I want you to, I want to see you succeed. How's your arm doing?
It's getting there. A lot of rehabilitation and physical therapy.
Yeah, it looked bad last time you were in.
Oh,
there.
yeah, it was pretty bad.
All right, well, good. I want you to get better. I want you to be successful. I think it looks like you're doing those things, so good for you. Now, as for the case here, we're on a plea setting. What is our status?
Yes, Judge, we have an offer. We're ready to accept it. It's conditioned upon his plea in UA today, which he gave, but we believe that confirmation of that was sent directly to you. It was not sent to probation this morning, since you were sent him down.
I don't believe he came down to probation from our knowledge. Maybe he went down to bond.
Did you go to pretrial services? Okay. Well, let's, is Lydia here?
Yes.
Do you have a status on this one?
His UA?
Yes.
It's negative.
Okay, great.
We just needed to confirm that with you.
Okay.
before
Yeah,
today.
we'll get the
Very
paperwork
good.
done.
Get
Thanks,
the
Judge.
paperwork together and let me know.
Thank you, Judge.
Yes.
If I may, Ms. Hughes, I think it has an update on the victim in their case.
Okay.
On the Lazaro Gonzalez Espinosa.
We attempted to contact him, Judge. There was no answer at his phone, and I did confirm that he had previously been told that if he wanted to attend, he should plan on being here at 9 a.m.
Okay, well then we'll make sure that we give the person the sentencing date. This is Lazaro Gonzalez Espinosa.
That's correct, Judge.
All right, Mr. Gonzalez Espinosa, can you approach, please?
Yes, sir.
Court call CR 23-5233F, the state of Texas versus Lazaro Gonzalez Espinosa Jr. Can state, please make their announcement.
Allison Boost for the state.
Defense?
Trey Thompson for Mr. Gonzalez Espinosa, Your Honor.
And are you the same Lazaro Gonzalez Espinosa who in CR 23-5233F is charged in count 1 of unlawfully carrying a weapon on prohibited premises and count 2 aggravated assault with a deadly weapon?
Yes, Your Honor.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
This aggravated assault with a deadly weapon is a second-degree felony. State, what is the range of punishment for a second-degree felony?
No less than 2 years, no more than 20 years in Texas Department of Criminal Justice, and up to a $10,000 fine.
Sir, do you understand that is the range of punishment that you face for that charge?
Yes, Your Honor.
For the unlawful carrying of a weapon on prohibited premises, that's a third-degree felony. State, the range of punishment?
Third-degree felony is no less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that's the range of punishment that you face for that charge?
Yes, Your Honor.
All right. Did I swear you in? Huh? Did I swear you in?
Did the judge say you're gonna tell the truth, the whole truth, and nothing
Yeah.
but the truth?
I did?
Yeah.
So you're gonna tell the truth?
Yes.
Good deal. All right. I just have to do that, and I had forgotten. That's on me. I
Oh,
apologize. All right. I have before me paperwork that indicates that you'd like to enter into a plea bargain agreement. I'm showing you the admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there is a list of rights that you would be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes, Your Honor.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, Your Honor.
Make sure that you speak up because she's taking down everything you
Okay.
say. And is this your signature on the final page?
Yes, Your Honor.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, Your Honor.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding those rights, do you still wish to enter into this plea agreement?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied that the state fulfilled that obligation?
I am, Your Honor.
And do you believe that your client is competent to enter into this plea today?
Absolutely, Judge.
We talk about the evidence in this case, sir, because you have the right to know what that evidence is. Did you discuss the evidence against you with your attorney?
Yes, Your Honor.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Yes, Your Honor.
According to your plea bargain agreement, in exchange for your plea of guilty to counts 1 and 2, the state will dismiss a terroristic threat case. There will be an affirmative finding of a deadly weapon in count 2. The state will recommend 10 years deferred adjudication. There will be a fine, a fee, an evaluation, community service hours, and there will be no contact with various individuals, and you will have no firearms. Is that your understanding of the agreement?
Yes, Your Honor.
Would you like to enter into that agreement now?
Yes, Your Honor.
To the charge of unlawfully carrying a weapon on prohibited premises, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
To the charge of aggravated assault with a deadly weapon, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
Based on your plea of guilty, based on the stipulation of evidence, I find that there is sufficient evidence to substantiate your guilt, but I don't find you guilty at this time. I'm going to order a PSI. That means someone from probation will speak to you, make sure that you cooperate with them. They'll prepare me a report, and after I've received that report, we'll come back and do your punishment. Understood?
Yes, Your Honor.
All right. Thank you, sir. Is there anything else we need to take up?
Just briefly, Judge, States 1 does reflect, I think, that there's been an agreement not to oppose early termination at the halfway point should the court impose probation here. Just want to make sure that that's clear on the record. I know Mr. Espinosa has been concerned about that.
Okay. Is that your understanding of the agreement?
Yes, Your Honor.
And does that change anything that we've done today? Okay. It's what you want.
Yes.
Very good. All right. It's on the record.
Thank
Thank you,
Judge.
sir.
May we be excused?
You may.
Thank you, Your Honor.
So this is an example of one of those we were looking at yesterday where it said I, and then it says do judicially confess. You don't need to do anything to it
Okay.
here, but what I'm asking is if what you all are going to proceed on is only the stipulation of evidence,
Mhm.
which has been made clear, then let's have that language, because according to the case law, it says a judicial confession may be sufficient. So the guys previously, what they had in that admission is I
Name.
intended do judicially confess and stipulate, which may be belt and suspenders, but at any rate, if that is the limited
You're gonna do it
information-
right, right?
Information that we're going to proceed on, let's make sure that it's taken care of. and
Yes, sir.
buttoned up. Thank you, sir. Carlos Rubio, I give that back to you. Thank you. Cappuccino, I signed the waiver.
I got it.
Hello, Ms. Barrow, how are you?
I'm great, thank you.
I don't think I've seen you since the big news, so congratulations.
Thank you, I appreciate it. I was out last week, but I'm back working.
You're
I'm
back.
a quick announcement on
Who-
Herrera.
Herrera.
Mark Anthony.
So I have that we're here on arraignment on that case.
Yes, Your Honor. He was in TDC and released between last setting and this setting. I've not been able to reach him. I believe the state has also attempted with an investigator.
Yeah, we tried to see if he's been paroled or not. We don't believe that he is in TDC anymore, but has not showed up today. So we do not know.
Okay,
where-
do we know if he had notice of being here today?
Notice is sent to the attorney judge.
Okay, and
Your Honor, I haven't been able to reach him since he was in TDC because he was transported from Travis County to TDC quickly. I'd ask for one reset. I know the state is probably going to oppose it.
State.
Judge, this is our second arraignment. And so for that reason, we would oppose a third reset of this arraignment.
Very good. Please call his name 3 times. Can someone tell me what his current bond is?
What's the last name, Judge? Herrera.
Mark Anthony Herrera.
4,500 PR.
Very good. Please call that 4 times or 3 times. You could call it 4
Yeah.
times, but let's do it 3 times outside and let me know. If you're able to get in touch with him and let him know that he can be here before we issue a bond, a warrant.
Yes, Judge.
I'll give him time. So you let me know.
Thank you,
Put it in
Judge.
your hands before we get
Yeah.
off the bench today.
Thank you, Your Honor.
Thank you.
Thanks, Judge.
Yes.
Jimenez. My name is Nathan Osowski, Judge.
All right. Nice to meet you.
Good to meet you too.
Thank you for being, where do you live?
I live in Gerald, Williamson County.
Okay. Well, thanks for coming
Covering
down there to
for
Hayes
for
County.
James Fletcher.
All right. We appreciate you being, you're here on Jimenez.
Yes, sir.
Okay. Is he here?
He is here.
Your name again, sir?
We are requesting a continuance. Nathan Osowski, Ossowski.
Okay. Mr. Jimenez, come on up. How you doing, Mr. Jimenez? Okay. What's the issue?
Judge, I'm requesting a continuance. There's some developments from the plea paper, or rather the sentencing paperwork and the PSI that I think would be better addressed by Mr. Fletcher, who is his regular attorney, knows the county, knows the prosecutors, knows the process a lot better than I do. So I request that reset for the best interest of my client.
Well, what's the issue?
The issue is the requirement of going to jail and the SMART program.
Okay, why is there a jail requested?
Just because they have to be taken into custody to wait for a bed date for jail. Wait for a bed date for SMART.
For SMART?
Yeah, so it's not that we're requesting jail time, we're just requesting that he go to SMART. and wait for a bed date.
Right. You have to be taken into custody to go to SMART.
Correct.
And tell me about the SMART program.
Yeah, it's a 90-day substance abuse program. It's one of our best substance abuse programs that we do offer. It's not a lockdown program or anything, you know. It's
Okay.
one of the best ones that we offer.
Great. Well, you're here on his behalf. I think that you can make the argument in that area. If you want to step back and give him a call, let him know what it is, you can. But to argue whether he should go to the SMART program or not is something that I believe that you're capable of doing.
Yes, Judge.
Okay. Go and step back and let me know whenever you're ready.
So again,
All right. Do we have a prosecutor on your case?
Ally told me to come.
I've conferred.
Okay, come on. Your client's name?
Francisco Flores, and I'm Jessica Wynn, Huynh.
You've come down here to Hayes a few times,
I
right?
have, Judge. I live
Good
down
to-
here. So.
Good to see you again. Where do
Good
you
to
live?
see you. Driftwood.
Oh,
Mhm.
good for you. And you primarily practice in Austin?
Yes, and all the way up to Williamson County and all the other places, so all over.
Well, thank you for being here today. Okay, what's our status?
Judge, I have conferred with Elizabeth Schmidt, who's handling the case. She has reviewed everything that's in the file. She has subpoenaed the CPS records, which at this time are the only things that she believes to be still outstanding. She is confirming with Detective Elrod, but at this point in time, there is no indication that a medical exam was performed on the complainant in this case, and there is no indication that there were any additional interviews conducted of any additional witnesses. She is going to confirm that with Detective Elrod just to be especially sure. But at this point, again, all that seems to be outstanding are the CPS records.
Okay. Well, there's information.
That is information. We thought that there'd be a lot more to the case file, so getting confirmation from Detective Elrod that those things were not done is helpful.
Okay, very good. Well, given that there's not any more that we're expecting there, I want to kind of give you a timeline on this case. This is a charge, or the offense date is from 2020, and it was indicted 13 months ago. Given the gravity of the case, we're going to start moving it forward, and under the code, a child under the age of 14 years of age, their cases get precedent. So our next setting will be another pretrial setting. All right, we'll have confirmation from the state on those issues. Another 30 days after that, it would be a plea setting. That does not mean that you have to plea, but if there is no resolution, the next setting would be a trial setting. Just to give you kind of a timeline of what we're looking at so that you know what's happening in your case. That's 90 days out though. Understand?
Yes, Your Honor.
All right, you have any other questions?
No, Your Honor.
Very good.
No, Judge,
All
thank
right,
you.
thank you very much. After you get your reset, you're free to go about your business.
Thank you, Judge.
Do you know the timeline on those CPS records?
In my experience, it's whenever CPS decides to give it to you. I am sure we have a date on the subpoena for those records. CPS frequently notifies us that they are not going to be able to comply by that date.
Okay. Is your client in custody?
He is,
Is that
John,
him?
he's right over here.
All right, come on up. Tell me your name, please.
Oscar Pastrana. He's on the 9-3 docket.
Morning, sir.
Good morning, sir.
We're here on a pretrial setting. What's our status on this case?
Your Honor, we were appointed less than a month ago. This is our first opportunity, our first time in court.
Okay, do you have discovery?
We have discovery.
Do you have an offer?
We don't have an offer yet because the state is trying to track down some time in San Antonio.
We have made an offer, Judge. I think there's just still a dispute about what credit he may have towards that time.
Well, I'm not aware of the offer, but he doesn't get out of TDC until the 2nd of December, so there's plenty of time to figure out. We're gonna get it done by
Okay.
next time.
Well, we don't need to just wait until December for that purpose here. So that's fine.
I understand. What I'm saying is, we have 241 days credit now. In our opinion, they're gonna check that out. If we can move him to the plea docket, we'll take care of it then.
Very good.
And
As
it
you
certainly will
request.
be an offer that will not extend his time in TDC.
Okay, we'll be back in August then, and we will move it to a plea setting. State, can you please confirm for him the offer when you step back?
Yes, sir.
All right,
Yeah.
very good. Thank you, sir.
And wait till he comes down for a second.
Please make that a plea setting.
Okay, let's put that on the record. Can we put that on the record?
Come on up, Mr. Pastrana. What, you want to put the offer on the record?
Yeah.
Okay, well, I'm going to step outside while you do that. I think that it's inappropriate for me to know what that is, so I will step out.
No, we're fine. We're fine.
No, I mean, you can do it. You absolutely,
I can
Put it on
send
the
you an
record.
email with it right now, so
Okay.
it's in writing.
all right, very well.
I'm actually.
Okay. How are you doing, sir?
Good morning, Your Honor. So I'm here for Jose Palacio Perez. We just need a reset.
Palacio Perez. You may.
He is a Spanish speaker, Your Honor, but he does understand English though, so you can speak to him in English and he'll understand.
Very good.
Palacios Perez.
Page 4.
This one, Your Honor, we do have a recommendation. I did just confer with the prosecutor, Mr. Gilbert. So he's gonna look in to see if, whether or not he might be eligible for PTD. So I definitely want to see if we can get the green light for the application. So he's gonna staff that and see if we're able to put the application in. And if we are, we will put the application in as soon as we get the green light from Mr. Gilbert.
How long do you need to get that information?
It's not actually an application. His name is simply added to a list that's reviewed by a committee for a thumbs up or thumbs down.
Yeah.
They meet approximately once a week.
Okay.
So I would say at least a week.
Very good. Well, then we'll just move this to a plea setting, and it sounds like within a week we'll find out what it is.
Can we request the 30 days, Your Honor? So I also want to
Yes,
consult
sir.
with an immigration attorney to make sure, even if he does get an offer of PTD or a deferred offer, what consequences he will be facing. So I want to be able to consult with an immigration attorney for that. This court has, I believe, August 20th available.
Absolutely, we'll do it. Let's make sure that we get a 30-day reset on this one for the 20th, so that you have time to take care of those things. Our next setting will be a plea setting. That does not mean that you have to plead, but if there is not some resolution at that point, whether it's this program that you're requesting or something else, your next setting after that would be a trial setting. Just want you to understand the timeline so that you know what's going on in your case. Understood? Very good.
Yeah, thank you, Your Honor.
Thank you.
Is there a form that we need to sign for?
She has it for you, and after you've completed that, you're free to go about your business. Becky, will you please make that a plea setting? All right, yes, ma'am.
Hi, Judge. You're ready for a plea on Mr. Tompkins.
Tompkins, all right, come on up, Mr. Tompkins.
Yeah, let's swap up.
Court calls CR 234317F, the state of Texas versus Paul Henry Tompkins Jr. Can counsel please make their announcements for the record?
Right, please. Philip Gifford for the state.
Natalia Sokos for the defense.
And are you the same Paul Tomkins who in CR 234317F is charged with possession of a controlled substance, methamphetamine, 1 gram or more, but less than 4 grams?
Yes.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
This is a 3rd-degree felony. State, can you state the range of punishment?
no less than 2 years, no more than 10 years in the Texas Department of Criminal Justice with a $10,000 fine as the max.
Do you understand that that is the range of punishment that you face for this charge?
Yes.
I have paperwork here that indicates you would like to enter into a plea bargain agreement. I'm showing you what is the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes.
On page 4, there are a list of rights that you would be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes.
Make sure you speak up.
Yes.
And is this your signature on the final page?
Yes.
Mr. Tompkins, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes.
Are you a citizen of the United States?
Yes.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Are you satisfied that the state fulfilled that obligation?
Yes, Your Honor.
And do you believe that Mr. Tompkins is competent to enter into this plea today?
Yes, I do.
Mr. Tompkins, the reason I ask about the evidence is because you have the right to know what the evidence is against you in a case. Did you discuss that evidence with your attorney?
Yes.
And do you believe your attorney has provided you with effective assistance of counsel during the course of this case?
Yes.
According to your plea bargain agreement, in exchange for your plea of guilty to the charge, the state will recommend 3 years deferred adjudication. There will be a fine, restitution, a fee, an evaluation, community service, and the DWI intervention program. Is that your understanding of the agreement?
Yes.
Would you like to enter into that agreement now?
Yes.
To the charge of possession of a controlled substance, methamphetamine, 1 gram or more, but less than 4 grams, how do you plead?
Guilty.
Are you pleading guilty because you are guilty
Yes.
for no other reason?
Yes.
Based on your plea of guilty, based on your judicial confession, I find that there is sufficient evidence to substantiate your guilt, but I don't find you guilty at this time. What we're going to do is order a PSI. That means someone from probation will talk to you. Make sure to cooperate with them. They'll prepare me a report, and when I get that report, we'll come back and do your sentencing at a future date. Understood?
Yes.
Thank you very much. During this time, that'll probably be 60 days when we come back. Make sure that you're staying clean. And are you going to NA and AA?
Yes.
All right, good. How often do you do that?
When I can, like once a week.
Okay, do you have a sponsor?
Not yet. No.
Okay, well, keep going. If you can go,
Yeah.
we will. When we get to probation, we're going to be going more frequently.
Yeah.
Because I think this is really good and I see progress and I want you to be successful. So if you can start now
Yeah.
and get it going.
I got my job back. That helps.
What's that?
I got my old job back, which helps a lot.
Well, good.
Yeah.
I'm glad to see things are looking up. This is good, Mr. Tompkins.
Yeah,
All right, very good. Anything
Thank
else?
you, Judge. Nothing.
Nothing.
Defense.
All right, we'll see you then. Keep doing the right thing.
Thank you, Judge.
Tom, give you a officer in the back of the courtroom. Do you know what he's?
I'll find out, but he didn't know.
How you doing today?
Good, how are you?
Good. We're almost done here, I think.
Yeah.
Let me get the bailiff back and then we'll take that up. State, we're gonna take up around hell. Becky, what do I understand on Ron Hill that he won't be here today? Okay. We'll reset it for tomorrow.
Judge, I never heard back from him. He said he's definitely at work.
Okay. Before you bring them in, let's handle one. Well, no, we'll take care of it. You have somebody, we'll take care of it. I don't want anyone else in here when we take up another case in a moment. And that way you're also free. Okay. So Becky.
Sorry, Judge Hayes.
Quiet, please.
There is no one in the office.
I know, I'm sorry. So I'll be real quick. Can we then reset it for Thursday?
I can try, but he did not respond to me when I told him he needed to file a motion for continuance.
Oh, he hasn't filed it yet?
He didn't file anything. He did not respond.
Okay.
I told him his client needed to be here and he needed to file a motion for continuance. I never heard back from him.
There is no motion for continuance on file.
No, there's not.
Okay. Yes, sir. Yes. You're here on whom?
Mr. Serrano, on page 5.
And he's coming up?
He is present.
Okay, come on up, Mr. Serrano. All right. Good morning, sir.
Good morning.
We're here on a plea setting. That does not mean you have to plead, but what is the status?
We're hoping for another plea setting. This case is somewhat complicated. There's a pending charge in Travis County as well as a pending charge here. In both counties, it has cycled through multiple prosecutors. And today the offer had very significantly changed from what we had understood it to be. And so we're hoping for some time to consider that and to maybe get the original offer back on the table.
Okay, well, I'm going to give you 30 days to do that, but we will be set for trial. This is in August 2023. So that will put us, when we come back, at 1 year out. He's been in custody now for over 100 days, and the case is from 2017. You have your right to a speedy trial. The victim has a right to be heard. And here in this case, the victim is under 17 years of age, the alleged victim. And so we will move forward to a trial setting. If you all come to an agreement at any time, you're welcome to come before the court and I will take a plea. But we'll move it to the next trial setting. Understood?
Yes, sir.
All right. Anything to say?
Nothing to say.
We understand, Judge.
All right,
Thank
very
you.
good. All right, guys. We'll see you for a trial setting.
Thank you, Judge.
Thank you. Mr. Ron Hill, come on up. State someone on Ron Hill on the trial docket. I understand your attorney is not going to be able to make it here today. If he reaches out to the court and we have another date between now and Monday, we may come in to take up any issues he may have.
Okay.
But right now there are no motions before the court. We were set for trial on Monday. State, are you ready to proceed?
State's ready, Your Honor.
Okay. Very good. So you understand, we'll be here if there's anything we need to take up. Your attorney knows how to reach out to the coordinator.
Yes, sir.
All right. So make sure you're here on Monday. And if there is something in between now and then.
I'll be notified.
Okay.
Yes, sir.
Very good. All right,
Thank you.
sir. Where are you going now?
Back to work.
Back to work. I thought it was. Good for you.
Yeah, I came in from work and I'll head back.
I know. And I don't want to waste your time anymore. Get back there and keep doing the right thing at work.
Yes, sir.
All right.
Appreciate
Take care
you.
of your kids.
Oh, yeah, busy.
You've told me that was one of the reasons.
Yes, sir.
You needed to get everything straight.
Yes, sir.
And you've been taking care of them?
Yeah.
That's your job.
Yes, sir.
All right.
Appreciate
Thank you. Yep. After you get your reset, you're free to go about your business.
Yes, sir.
Judge, I don't have a reset for him.
Oh, okay. You know, it's set for Monday.
Monday.
All right, we'll see you then. Yes, how are you doing, Mr. Dudley?
I'm doing well. How about you?
Good.
So we have Miss Hart on your docket.
Ms. White.
On your heart.
All right.
And-
State someone here on Hart.
Your Honor, I finally got Hart's permission, and I don't want to say too much.
Can we bring her up?
Absolutely.
Okay.
I'm a little concerned about violating HIPAA.
Okay, well, because of the computers?
Right.
Okay.
I don't want anything, any of our mental health stuff here.
Yeah, okay, I'll take care of it.
Okay, cool.
I want you all to be able to approach when you have concerns. This is.
Well, it's only on mental health stuff. The rest of it I'm cool with.
No,
You know what I mean?
and I understand. I hear you.
Okay.
We're gonna take care of it.
Awesome. You have like a button?
We'll do it. I do.
Okay. All right, thanks, Judge.
Yes, let's get her coming up.
Not yet.
Okay.
Let's not pressure.
Duncan, come here, please. I want to take a place. Yeah, I want to take that up, and I think you should get someone else in here. Do you have anyone available? Huh?
Somebody right now.
Okay.
The officer is here for that.
What's that?
That officer is here for that.
And what's going to happen?
He said, telling me he was asked by probation to make a reference to something to do with a zone. I don't remember the word he used.
Okay.
Safe zone or something like that.
Okay, let's get someone in here. Selena Gonzalez, please call that name 3 times.
Yes, Your Honor.
All right, are we ready to proceed?
Yes, Judge.
Very good. Come on up. On Eric Jimenez. Ruby, are you ready?
Your right thumb, please. Straight up, straight down on the pad, and then straight up, straight down on the box. Yes.
Court calls CR 22-1798C, the state of Texas versus Eric Rivas Jimenez. Can counsel please make their announcements for the record?
Allison Booth for the state.
Nathan Osowski for defendant.
And are you the same Eric Jimenez who in CR 22-1798C is charged with possession of a controlled substance, methamphetamine, 1 gram or more, but less than 4 grams? Are you that person?
I'm that person. Yes, sir.
Okay. And are you the same person who pleaded guilty to that charge?
Yes.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. We're here today for your sentencing. I have received a pre-sentence investigation report from probation. Counsel, have you had the opportunity to review that report and discuss it with your client?
I have, Judge.
Okay. And are there any corrections or modifications to the contents of the report?
Yes, I would request that the SMART program and the requirement for going into jail.
Before we go there, I think you want to go to argument about that. I'm just saying, I want to give you the opportunity if there are any corrections or modifications to the contents of the
No,
report.
Judge, the information that my client had given is correct and true on the report.
That's good. Now, is there any legal reason we can't proceed to sentencing?
There is not, Judge.
Okay. State, any argument?
No, Your Honor.
Defense, your argument?
Yes, the PSI as well as the sentencing paperwork indicate that my client will be taken into custody in regards to starting the SMART program, a rehabilitation program. I think it's unnecessary and actually has a tremendous amount of negative impacts in regards to my client. One is that he would lose his job. He works at Flextronics as a supervising manager, where he makes $78,000 a year, and he'll be there. He's been there for about 9 months. It'll be a year in September.
Bless you.
He needs that money. He owns his home. He pays $1,450 for mortgage, and he has about a year left in those payments, and he would be losing his home if he were to lose his job. He's also trying to gain custody of his children, and having no job, no money, no income would defeat the purposes for him to try to get his children back. He has a car payment of $800. He would also lose his car because he has no job, which means he has no money coming in to make payments for his life and lifestyle for his family that he wants to be able to support. There's an opportunity for him to start school through his work. Another opportunity that would be completely dead if he were to be fired for losing his job going into jail. He's going to be working to get his AA, or rather his BA. He already has his AA. He has started NA through Zoom, and the requirement for gel and the SMART program also was not an agreement that was made with the state, with the defendant. It was put on by probation, and we had no notice of the condition whatsoever before this morning. I know that speaking with my client, he'd be willing to do any kind of programming that the court would require him to do. He just asked that he be able to do a situation so he would be able to maintain his employment. And I'm finished. That's it.
Okay, it's a good argument. I knew you could do it.
I know I could do it too.
All right, but here's the thing, Mr. Jimenez. Less than 22 days ago, you came in here and tested positive for methamphetamines. And the work that you have, you're going to lose that job if you continue to use methamphetamines. I mean, it's not, but you're saying, well, this time it's going to be different. Is that what the argument is? I mean, I want to hear from you.
Yes, Judge, it is.
Why is it going to be different? Because your counsel just laid out a lot of great reasons for you to be clean.
Yes.
But those reasons existed 22 days ago and you used methamphetamines then.
Correct.
Did you get tested today?
No, I have not.
Would you be clean?
Yes.
Sure.
I'm positive.
When was the last time you used methamphetamines?
On the Friday before I came to court.
Okay. Well, this will make a big impact on what the court does. So let's get you to go down and take a test right now, and then come back and let us know what the status is.
Before we get off the record, Judge, can I inquire my client just for a second?
Yeah.
Would you be willing and able to do any kind of treatment option that the judge would have you do that would not cause you to have to go into jail and lose your job?
Yes.
Would you be willing to do intensive outpatient therapy? Would you be willing to go every day if the judge told you you had to go every day?
Yes.
Okay, that's it.
Okay, very good. Any crossing the state?
No, Your Honor.
All right, you'll step back, go take that. Is it going to be through probation or through pretrial services?
We can get him to go through probation.
Okay.
I can let him know.
Thank you for taking care of it.
Thank you.
All right, as soon as you're back, we'll come back and take care of this. Are we ready to proceed on Hart?
Yes, I am.
Okay.
Yes, sir.
Just want you over here.
Yeah, that's right.
All right, let's take up next. Looks like 2, we're good. Page 3, Mr. Dickerson. Mr. Dickerson here.
Right here.
All right, sir, how are you doing today?
Fine.
Okay, so we are here. I received something, was it from pretrial services or from probation? Lydia?
I believe it was pretrial, Judge, is what I'm being now at that.
Yes, because if it's bond conditions, it would be pre-trial.
Okay, that's right. So let's just get that in here and come in and let's discuss what is going on here. We had been approached by the supervisor at pretrial services. What's the status? What's going on?
From my understanding, he needs to switch his GPS and he does not want to switch it until it's court ordered by you.
Okay, so why does he need to switch it?
We switched companies and then I believe we need to add an exclusion zone and that's why SMPD is here.
Okay, does Mr. Facundo need to be here to?
I just
discuss?
called him up here.
Okay, why don't we do this, just so that everyone's clear on what's going on, just have you step back for a moment. It doesn't take him any time to get up here, and then we'll put it all out to discuss, all right?
What do you mean, go sit back down?
Yeah.
He'll be up here soon.
Okay, he'll be up here soon. All right. Okay, Ms. Destin, can you come up, please? Kimberly Destin. You're not quite as chipper as you. Okay? Huh?
Yeah.
All right. How are you, man?
Been better.
All right, so 30 days ago, you stood here in front of me and said that you would get an attorney, and you knew that there would be consequences if you didn't. Did you get that attorney?
I've been trying to, but I lost my job and it's been difficult to get an attorney. But I've spoke to some attorneys and I'm trying to work on it. One be able to get something until the first, because I only get disability.
Okay, what we're gonna do then is, I told you there were gonna be consequences, but I wanna give you a little leeway. Because you told me you'd have this done and I took your word for it. What I want you to do is speak with pretrial services. They're going to oversee your time on bond. Okay, so we're gonna start that through pretrial services. Lydia, and what we need to do is come back in 30 days and you either have an attorney by then, or if you're telling us that you cannot afford one because of a change in your employment status, then you can go and make a new request.
From my understanding, it's still, I make too much.
From disability?
Right.
Okay, and what was your job?
Oh, TSA.
TSA?
Yes, sir.
But you're not there anymore?
No, sir.
Okay, well, let's just have them speak to you from pretrial services. You'll have a reset in 30 days, but in 30 days, this has to be taken care of because we can't move forward. Your case is a serious case.
Yes, sir.
And you understand the consequences. We talked about them last time.
Yes, sir.
Okay, this is that one more chance,
I got you.
right?
Yes, sir.
But then the next time that would be me just not understanding that you are not doing what the court's requesting, okay? So I'm gonna give you another chance, okay? Try to get it done.
Appreciate it.
All right,
Thank you.
there's Ms. Lydia, she'll help you.
Yes, sir.
Judge, may I approach real quick?
Yes.
Standard conditions for her, do you have any specific things?
No, just please help her to either find an attorney or if she isn't, if she is eligible, then have one appointed, but I
Okay.
understand even she's saying right now she's not eligible.
Okay, we'll do that. Thanks,
Thank you.
Judge.
Hello, Mr. Daniels, how are you?
Great, except I've got a brand new client, less than 7 days on it, no discovery, need a reset for Jasmine Richard.
Is Ms. Richard here?
I think she's in custody,
All right, well then we need to get her up.
but I'm juggling another court with lots of other people in custody too.
Okay, well, I'm gonna bring her up because she needs to know what's going on in her case. Come into the courtroom. I understand if you want to go to the other court and come back and tell us when you're ready, we can get that person up.
That's what I'll do.
At your
I'll come back
convenience.
because we've got many more people over there to deal with than just the one here.
Okay, well, we need to do it with her presence.
Okay.
It's not your day, it's not my day, it's not the state's day, it's her day in court. So let's give her her day.
Thank you.
Thank you, sir. Is Mr. Facundo here?
You should go his way, Judge.
Okay.
Yes, if you're right on that.
Oh, are you here for Ms. Gonzalez?
Yeah.
Okay. Have you called her name 3 times, deputy?
I've not called it yet, Your Honor.
Okay. Have you had any contact with your client?
Yes, I have some contacts, and then I got a recording that that number's been disconnected, so I'm trying to find her.
Okay. Well, if you have the opportunity to find her, please let her know that.
I'll and call her and see if it's going, if she doesn't work, and she might not pay her bills.
Okay, and we'll give her until 4 o'clock today to get here.
Your Honor,
Yes.
this is Mel from the police officer. She did not report for
Yeah,
the PSI.
I'm gonna go call her, but I need to be in Judge Tibby's court, so like other persons, so.
Okay, well, we're going to, we won't put out the warrant until 4 o'clock, but if she can get here before then, we'll receive her and not put out the warrant. So she has a motivation to get here.
Okay, thank you.
Thank you.
I'm sorry, Judge, who was that on?
Selena Gonzalez, page 3, national hearing. There's already a warrant for her.
What a great start.
Okay, who else do we need to take up? That's Josue Crespin. Can you come on up, sir? Deputy, did you ever send him downstairs? Did you send him downstairs? Let's come, let's approach here first. I need to talk to him. And where's he going? If he's the warrant, don't let him go anywhere.
You said you wanted him to go downstairs. He doesn't know about that yet. I don't think so.
He hasn't gone down there? We can do it for you.
Well, that's why I waited.
Okay. All right. Sir, so evidently you have a warrant. I was not aware of that. What's that? Okay. Is there anyone in the building that can help? Okay, well, let's take him into custody. And at that point, we need to give him notice that he wants to apply for an appointed attorney. Please let them know. All right, thank you. Yes. He's not here.
Yeah.
Okay. Samuel Ariola.
It's a bench warrant, I did not execute it.
Okay. So who then? Is there anyone else who's waiting for an attorney? Ms. Destin, you've been handled? Can you check that one for me, Donkey? Are you? Did you go downstairs to fill out the form?
No, I'm gonna try to hire one.
Okay, well then come on up. Let's get an order to report, please.
That was my invitation.
We need to work on your invitation.
Is this for Cortez?
Cortez, I'm waiting on paperwork. We're gonna get something done on that today.
Okay.
Paralysis, Donner. We're still waiting on that DNA evidence, I believe.
Why is he in custody?
He bond forfeited and then was arrested in Travis County on an aggravated kidnapping charge. And we bench warranted him back over here.
Okay. What then? We need to get him up.
Okay.
So let's get both of them up. Okay. Paralysis and.
Well, I'll need to sign.
Cortez downstairs. Okay,
I'll-
so paralysis.
I'm good.
All right. Tell me your name.
Warren, last name Amanda.
Quiet, please.
Okay, so it's my understanding that you would like.
I would like to time to hire one. I have unfortunately have not had an income. I've been in outpatient services and went back to school for my HVAC certification. I do now have a job lined up. It's just waiting for the background to go through.
So you haven't had a job. How are you going to be able to afford an attorney?
I have one lined up. It's just background going through right now. That's just waiting on, it should be done by probably today or tomorrow. And then I'll have my start date of this week or early next week.
Okay. What I'm going to ask you to do is go down and fill out that form. I want you to be able to have an attorney until such time that you can pay for one. But if you can't, what I'm hearing from you right now is that you can't afford one today.
Today, no, not at this moment, but if, once I
want you-
start my check coming in, I will be able to pay the fee for a lawyer to represent me.
Okay, well, Donkey, if you could please let her know where that is and go downstairs and fill out that paperwork. Because again, as soon as you can have the attorney of your choice, but in the meantime, we need to get things taken care of in your case.
Yes, sir. I was told I could possibly ask for like, I guess like the 30-day extension to be able to hire an attorney for my next court visit. That way I can have that.
We're going to do a 30-day. But I want to make sure that in that 30 days, either you have this attorney that we've appointed or you have your own attorney. Okay. In no way am I trying to get in the way of you having someone else, but I do want you to have a defense attorney. Okay. I want you to have representation. This is for your own good. Donkey, can you handle that? Okay, she's going to go downstairs real quick.
Judge, she already filled out an application and it was denied based on her unemployment income that she's receiving.
That's right. Forgot to mention it. I was on unemployment. My unemployment has officially run out as of today.
Did you tell them that downstairs?
No, I haven't gone downstairs.
Has your application changed since you filled out your original application?
Yes and no, because when I filled it out, I was receiving unemployment, but now my unemployment has officially run out. I've run out of benefits, so now there is no income. Technically, yes, there's no income.
Then she would need to fill out a brand new form.
That's right. So your status has changed.
Yes, sir.
Okay. We tried to do it several times. Let's go downstairs and get that done.
Hart, did we take Hart off the jury docket? I just want to make sure.
So was there a separate?
There was a separate setting like 2 or 3 weeks out.
She's on our August 12th jury trial docket,
Yeah.
Judge.
Oh. For a different case?
No, for these
just the same
cases.
case, but I
Oh,
was
that's
just
right.
making- She said I need to make sure and check with you that.
Well, yeah, then let's keep that. Do you think you can get it done in 2 weeks?
I don't know, maybe.
All right, well, if you can't, then you can come back and let me know. Look, I understand what's going on here. We're not trying to push what we do. It's just we have.
No.
So-
I mean, I
All
don't
right.
want her decompensating as well, so I
That's
just
right.
was checking with Becky. So
Okay,
we
yeah,
have-
that's right.
We have a pretrial 30 days out, but we still have a jury setting.
So this was just because we wanted to come in and let you talk about status.
Right, it's just, it was a status hearing.
Okay,
right.
all right.
So do you want us to leave it on the jury?
Yeah, I want to
docket, or-
leave it on the jury.
Okay.
And if we can't, then we can't, but we're moving in a direction.
I figured we were.
Okay, very good.
And I've requested the calls for service and I've requested baby rush.
All right.
Okay, there's an extra overhang.
White Galarza donkey. We got Facundo here. Mr. Dickerson, can you approach, please?
Mr. Dickerson has been advised about the shorts.
Okay. Thank you for coming up.
Yes, Your Honor.
So what we were talking about was what was the status and what we needed to do today and what were the changes that need to be made. Can you lay those out for me?
The only change as of right now, according to the order that needs to be made, is the device switch to the device we're using in our department.
Okay. And what device did he have previously?
He has a device with Safe Monitoring Solutions. So prior to us getting the contract for our own GPS devices, all defendants were referred out to a third party for GPS installation.
Very good. Okay, so can you take care of that for me?
I talked to his office and they told me repeatedly that I could keep my current company that I've been using since last December. We're almost at trial and my billing is through a third party. And at the moment, I can't pay to switch devices. So we're almost there, we're almost at trial. And suddenly with, what was it, a day's notice? Something like that, they requested me to change devices.
How long ago was that?
That was at July 4th. So I think it was the 3rd, right before the holiday. And they told me I'm in full compliance. So he's saying that he's requesting me to switch companies, but the office, he even told me last time I spoke to him, I'm in full compliance. There's no need to switch. We're almost at trial. It's August 12th.
There is a need to switch that he's argued. Is there the possibility of doing the exclusion zone that you're requesting and him be on the system that he's on right now, and you still be able to oversee his pre-trials?
Not as immediate as we are now, since it's through a third party. If a violation was to occur, the third party will receive that violation and then notify us via email. How long that takes, maybe 30 minutes, 45 minutes, versus the immediate violation coming to the officer, text, email, once it occurs.
Okay, and is there a reason for concern that there are violations?
The concern that was brought up was from San Marcos Police Department.
And what's that?
Being around San Marcos City Hall, taking pictures of vehicles.
Which is untrue.
Okay, what's that about?
I wasn't at City Hall. I went to the area behind the Catholic Church here in town, and I never went near. I drove by City Hall, but then I received, that's his explanation. It's untrue. I never did that. And I have a GPS monitor on my ankle. He should know that, right?
Well, I think that's the point, is that he can't know it because it has to go through a third party.
He said 45 minutes. That's, how long ago was that? A month ago, almost?
It was this month, July.
So do you have evidence that he was in the location that you're
I have
alleging?
not asked Safe Monitoring Solutions if he was around that location during that time period.
Yeah, so with 1 day's notice, or I believe, maybe 2, I didn't even go to the location. They requested an exclusion zone, me to change companies. San Marcos PD would not provide an explanation. At least he would not give me their explanation.
They have an
And
officer from San Marcos Police Department available.
Can you approach, sir?
Yes, sir.
Ruby,
We're going on the record in CR 235467F, State of Texas versus Morgan Dickerson. Can council please make their announcements for the record?
Allison Boost for the state.
Mr. Dickerson, you're representing yourself in this case.
Mhm.
Let's make sure that it's a yes or a no, because
Yes.
just taking down what we say. Okay, so the question here is about location of Mr. Dickerson. And do you have knowledge of that?
Yes, sir, I do.
Okay, can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your arm down. What's your name?
My name is Joseph Osborne.
Okay, and how are you employed?
I work as a police officer at San Marcos Police Department.
Okay, and so tell me what's going on that we need a change for the defendant's conditions.
So on July 1st, I was made aware of a call for service at City Hall, where Mr. Dickerson went up there and was taking videos and pictures of buildings in that area, which is right next to St. John's Church. And then an employee who was about to walk into the building suddenly turned around and noticed that Mr. Dickerson was right behind him recording with his cell phone. And then when he questioned him about it, Mr. Dickerson told him that it was kind of just a case of mistaken identity. And then from my understanding, that was also confirmed by that third-party GPS monitoring system that he was at City Hall on that date.
Okay. Anything else you want to tell the court?
No, sir.
State, any questions?
No, Your Honor.
Defense, any questions?
Well, yes. The first most important thing is, was I at City Hall, yes or no? Was I outside City Hall?
Yes,
Do you have evidence of that?
there's cameras on City Hall, yes.
Okay, do you have pictures, any evidence here? Have you sent it to the court?
No, this is not that type of a hearing.
Isn't it? It's about an exclusion zone, correct? And you came here just to verify the reason for an exclusion zone.
Yeah,
So
which
we're
is what I
trying-
just told the court.
the truth is exactly what I told you. I parked on the edge of the parking. I drove past City Hall. There's a parking lot adjacent to the Catholic Church. I got out, went behind the Catholic Church. My phone was out. I had headphones in. I don't know how you would think that. First of all, is it illegal to take video or pictures? Now, is that an issue? There's no reason that
What
would
is
be a
the
problem.
issue there with him being at City Hall?
I could speak to that as well, Judge. For me, it's just concern. And on behalf of the police department, it's concern that sometimes we've seen in the past that that's a probing type behavior when someone's finding targeted violence. They'll go to a location such as the City Hall, examine what kind of security measures are in place and kind of controlled access, which was an additional concern for me when the employee that was attempting to get into the building noticed how closely he was being followed behind.
Is there anything, have there been any charges for any threats?
No, there have not. Again, that was just concern. It wasn't a criminal charge or criminal offense.
Okay, do you need to go to the City Hall?
Perhaps. My father owns a real estate investment company. And if I accompany him, I might need to go to City Hall. And depending on the distance from the location, that's right in central San Marcos. And so on a daily basis, I might go by there. It doesn't make sense. Why would I need an additional exclusion zone for City Hall? I've done nothing. They don't even know if I was taking pictures or video. It's just ridiculous. I think anyone could see that. It doesn't make sense. And we're almost at trial. And like I said, his office said that I was in full compliance. I could keep my current company. There's no evidence of any wrongdoing for an additional exclusion zone. They told me I could keep the same company, yet here I'm being requested to change it when I had the arrangements already made through trial for payment. It just doesn't make any sense.
Very good. State, would you like to add anything? Any argument?
Your Honor, obviously, there's pretty serious charges that the defendant is facing. We are set for jury trial based on my review of the evidence, and I'm sure the court has access to the probable cause affidavit. I think the court can also understand the safety concerns of the San Marcos Police Department. I don't think the defendant has articulated any particular reason other than financial hardship, in which case we can look into alternatives in terms of the court covering those costs of switching to the GPS provider that pretrial services needs to be able to actually continuously monitor him. I don't think it's an unreasonable burden, and given the safety issues in this particular case, I think it's warranted.
Okay. May I say something?
May.
I think that the requirement to have a GPS might itself be removed. look what I'm dealing with. This is since December, right? So that's 8 months I've been wearing this, no issues. And when they do come up with something, I went to the church, I had my phone out, which, okay, how many people are doing that? It doesn't make sense that they.
Are you saying you weren't on City Hall grounds?
No, I wasn't. Well, I wasn't at City Hall, the building itself, but their parking lot is adjacent to, I don't know how the buildings are, the ownership there, but I wasn't at City Hall. I know where City Hall is. I passed it.
Do you deny
And-
that you were taking videos of someone going into City Hall?
Yes, I deny it. It's untrue. And so what I'm saying is that the GPS right now is an expense and it's not providing any benefit to the state or to myself, because they should have, see, it should work both ways, right? I was wearing a GPS. They should know I was not outside City Hall. Yet they're claiming they have this evidence that I was. I just think that the GPS itself is just at this redundant at this point.
Okay, his point is well made. Is there any evidence from the third party that you have requested afterwards to show that he was at City Hall?
Due to Mr. Dickerson not being assigned to me, I have to get my laptop to check the officer notes.
Okay, well, let's check it. I mean, let's know what's going on if we're going to accuse him of something. Anything else you want to add?
No, sir. The police department, I believe, does have that information that you're requesting about the GPS verification. I don't have it personally on me, but.
Okay.
Can I say?
Well, if you want to step back and get it, you may.
Sure.
All right.
Can I make one more point? I live adjacent to the exclusion zone, the property that's the exclusion zone, next door neighbors. And so I have an exclusion zone set up to the property I live adjacent to. It's.
Where do you live?
Do you need the address or?
Yeah, I mean, it's the probation, pretrial knows where you live.
Yeah, and it's, if you look at it, it's an apartment complex. I live right adjacent to it, like adjoining property. So to me, it didn't make sense that I would need a GPS.
Okay, well, everyone's looks for further evidence. We'll go off the record. Everyone can step back.
Okay.
And we'll look at what's going on. All right, look, your point I'm taking and I'm considering, and I understand the position that you're making. All right.
Okay.
So we'll just stay cool. And
Go sit down again?
Yes, sir.
Okay, I'm gonna step outside. I'll be right back.
Okay, but you'll be back. Is that right?
Yes.
Okay.
Judge, can I get his name on the record?
Jason Facundo, Facundo.
All right, are we ready on Eric? What did it show?
Negative.
Negative, very good. Will you tell me when you're ready?
Here's that report, Judge.
Thank you. I'm sorry? Yes. We started earlier on punishment. All right, we're back on the record in CR 22-1798C, punishment hearing in the state of Texas versus Eric Jimenez. We took a break so that you could go downstairs and take a drug test, and you were clean on that test. Is that right?
Yes, Your Honor.
All right, very good. Well, that's a start. Moving forward. Is there any legal reason we can't proceed to sentencing at this time?
There is not, Judge.
All right. Having found there was sufficient evidence to substantiate your guilt, but not finding you guilty, the court now grants your application for deferred adjudication. That will be for 4 years. There will be a fine of $2,000, restitution to the DPS and to the Hays County District Attorney's Office. There's a fee and the evaluation was completed. You will do 200 hours of community service restitution. The drug offender education program. You will do frequent random UAs. You will do the NA and AA. You'll begin doing those. You need to do those at least twice per week. I mean, this is part of you doing all the things that your attorney said.
Yeah.
The hopes that you have for your buying your house, and keeping your job, and keeping your children. I heard all those. You're going to need to be going to NA and AA, which will help you get there. Okay, I really believe that, and I hope that you do too.
Yes, I do.
If you want to stay clean, you will be on the specialized caseload for substance abuse. You will do an intensive outpatient program, which will be followed by supportive aftercare. They have requested the SMART program for you. It sounds like a very good program, but what I want to do, given everything that you have, is put whether you go into that program into your hands. Okay, do you understand what I mean? I'm going to order you to go to the SMART program, but I'm going to hold that in abeyance. What that means is if you take care of all of the things that you're requested to do and you continue to stay clean, then you don't have to go to the program. You're going to be in an intensive outpatient. You're going to be going to NA and AA at least twice per week. As long as you are doing those things, you'll be in compliance and you won't have to go to the SMART program. But I think meth is very, very serious. Okay. And if there is a slip up on the UAs or failure to come in and give a UA, then in that case, what we would do is you would be ordered to the SMART program. Does that seem like a fair opportunity?
Yes, yes, Your Honor.
It's completely in your hands, right? You control the keys to your success and where you will be.
Thank you.
All right, you understand that?
Yes, sir.
And if all of those things that you're telling me are for real, you now have the opportunity. You've been given the opportunity to go out and succeed. And I hope you will. Will you?
I will.
Okay.
Thank you.
Why can I believe it this time?
Why?
Yeah.
Because you opened my eyes, sending me to jail.
Okay. All right. Well, good luck. Let's hope this helps. And I want to see you doing everything successfully and to be a success.
Thank you.
Anything else we need to take up?
Nothing from the state.
Nothing from defense, Judge.
All right, sir, I have followed your plea bargain agreement. And because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. Says so, that will be added to your file. Good luck to you, sir.
Thank you.
Come on over here real quick. We have some signatures to do.
Can we use a fingerprint if you haven't already got it?
Fingerprints already have.
Got it.
All right, grab a seat. She'll come get you.
And Judge, I checked with Philip on that stipulation language.
Thank you.
Apparently,
Sign it
we
if
added
you
it
do.
to newer cases, but some of the older cases don't have it. So we're going to be double checking and adding it in as needed.
Sounds great. Thank you. Thank you. Sorry, Ashley.
Thank you.
Thank you. And these are yours.
Thank you.
You want him to sign it or?
I will get him to sign it after
Okay.
she sign it. Excuse me. Thank you.
Hey, Judge.
Thank you, sir.
May I be excused?
Yes, you may. Thank you for your patience.
Probation will quickly,
Sorry, Ruby. Does that hurt your ears?
Okay. So yeah, we follow regulations. We'll get you.
Judge, can I be excused for just a few minutes?
Yes.
Thank you.
You need me?
No, Judge.
Okay.
Just making sure. I think there was some paperwork from the client.
Okay, so we only have Mr. Dickerson left. And your name, sir? Vasquez?
Were you on Mr. Roscoe?
Mr. Ramirez, are you in jury trial?
Is he in jury trial down in the hall?
Yes, with Judge Dunn.
He made it sound like they'd be done by 11 o'clock. Do we know if they're still going? Okay. All right, well then. All right, Mr. Vasquez, where are you?
I just don't know.
Oh, no, get him. What's that? He wasn't? So when we talked to him yesterday, he said he would be done by But it's okay. What we're gonna do is ask Mr. Vasquez to stick around and we'll be back. Mr. Vasquez, you're free to go for now, but come back at 1:30. Okay, at 1:30 and I think your attorney will be here. All right, thank you, sir.
Your Honor, I'm not be making some traction on Mr. Taylor. Before lunchtime, would you like Mr. Taylor now to come back at 1:30?
On,
Andrew Taylor, he's incarcerated.
what are we doing? No,
We're
I
doing
just
the same.
wanted to give that gentleman the opportunity to leave the courtroom. No, I'm not trying to keep us from taking care of business, so keep on taking care of business as you do.
Yes, sir, I'm trying.
Are you ready?
Your Honor, I'm just waiting for S&P to send the report.
Okay,
They have the verification.
okay, we'll take a look at it. So what happened on Miss Maureen? Deputy, what happened on Miss Maureen?
She got David Mendoza as an attorney.
Okay.
Gave her a reset.
Very good.
I told her that did not preclude her from getting an attorney if she so desired.
That's right. Thank you.
And I am asking Attila if he's going to finish today. You wanted to know if Devlin was going to finish today, Judge Devlin. So I'll get an answer to that question.
I understood that the attorney thought that he'd be able to come over and just go over the
Is that
waiver
Ramirez?
paperwork with Mr. Vasquez.
Is that Ramirez?
Yes.
Okay. I should find out.
That's what I understood him from court yesterday.
You can say,
What's that?
you should remember, she kept telling him wrong.
Yeah, don't do it.
Don't say that. Because as soon as you do, it doesn't happen.
So Grace, guess who's coming back? And I'm not getting transferred to this court.
Listen.
Guess who's coming back? Sorry.
You know what it is. And you call her mommy. That's fine. No. Stop it.
And I'm thinking I think I may transfer him in here.
Why now?
What shenanigans are you?
I was telling her, we tried camera board here. I was telling her, bring camera. I don't have anything to do with it.
I got enough new stuff on our plate. We don't need to wait for people back.
So we're just waiting on Dickerson and then the rest are in custody.
No response yet.
Okay. All right. We let him out that back door for a second. I'm gonna go back. Let's just take 10 minutes. When y'all are ready, let me know.
All right. Grace, we worked together 15 years.
Are we ready on Dickerson?
Yes, Your
Yeah,
Honor.
but you're, okay, let's approach on that. Okay, what we did is we stepped back. Yeah, we can go back on the record. We'll be back on the record in CR 23-5467F. Counsel for the state is present. Mr. Dickerson, who represents himself, is present. We stepped back. Mr. Dickerson, I had asked you if you were at City Hall. You denied that. You said, yes, I deny that. Then you asked Mr. Facundo to go and prove it up, which I think is a fair thing for you to do. If they want to say that you were there, then show the evidence. You asked them to do that. Were you able to find any evidence, Mr. Facundo?
Yes, Your Honor, July 1st, approximately 2:40 p.m. His GPS device puts him at San Marcos City Hall, and then past that around other properties behind City Hall as well.
Have you had the opportunity to look at that evidence?
Well, that corroborates my story. I drove past City Hall.
Okay. Did you have opportunity to look at the evidence that shows that you were at City Hall?
No, I have not, but it's not accurate if it's showing me off the road, which it is. But I drove past Catholic Church, so in general, yes, it looks accurate. But it's exactly what I said. I drove past City Hall. It's right here at this location. The officer said I went to City Hall, and I just drove past. And so, have you seen this?
No.
Okay, so drove past City Hall, went here, and I'm not sure why, but I went to the back of this Catholic. Oh,
We'll let him.
so it's not showing one of the locations I went to, perhaps because of the tower there.
Your Honor, up here, City Hall, the church is over here.
Yes.
And
So
then these are other buildings that belong to the city of San Marcos.
drove past City Hall, went parked over here, went to this area. On the way out, turned around.
It's approximately
So
8 minutes.
And that's another thing. Why doesn't, if each ping is showing my location as I'm moving, why doesn't it show 2 for me leaving this area? Unless there is, no, there isn't. It's just 1. So it should show a second ping for me leaving. It doesn't, but.
So you're suggesting that that information there is inaccurate?
Yes and no.
Okay, well, I'm going to take the yes. Here's what we're going to do. I don't want you to use an inaccurate GPS apparatus. You will change it to the new apparatus that's being requested. And I'm also giving you the order, and this will be added to your conditions. Do not threaten, harass, annoy anyone at City Hall. Now, that may not be a criminal offense to annoy someone, but as part of your conditions, you may not threaten, harass, or annoy anyone at City Hall. To the extent that you want to go and see what is happening or see your government at work, I want you to have that opportunity. But if you are, for instance, following people as alleged, I'm not upset about that right now, but if you are following people very closely and holding a phone up to them, that would qualify as annoying someone. Anyone would not like that. And I'm telling you, while you are on bond, do not do that. Please get that changed. It's an order of the court. And please do not threaten, harass, or annoy anyone at City Hall.
Let me say this.
Do you understand?
I understand what you're saying, but there are 2 things I'd like to argue if I can, is that one, the GPS wasn't inaccurate.
Well, it was just inaccurate a minute ago. If this GPS is causing a problem, then we're going to get it changed. So please get it changed.
It corroborated my story though.
Okay, well, and that's why I am not saying that you violated any conditions, but what I want us to do is be very clear that if you have a GPS unit on, it is the one where it will be registered immediately and is completely accurate. There was a yes and a no, a yes that it was not inaccurate. We're going to have a new system, so please have that changed. That is part of the orders of your condition of bond. Do you understand?
Okay, so let me, if I can, just clarify all of this.
Yes, sir.
His office said that there was no issues with my current company. I was in full compliance. I've spoke to them more than once. So the current company was fine, they said. The officers are using.
Can we agree, though,
Okay.
they must not think it is okay?
I know, I'm
At
just,
this point, right? They must not think it's okay if they're asking that you change it. Are you asking that it be changed just to pester Mr. Dickerson? Or is it because there is a difference in what the service provided on the other GPS system?
The latter half, Your Honor, not to annoy or pester Mr. Dickerson, it's to accurately monitor.
And I think that's necessary because if you're in those locations, they need immediate access if you are going and attempting to threaten people at City Hall. I'm not saying that you have. I'm saying that there is evidence that makes me want to ensure that does not happen.
okay, I'm just trying to clarify.
Okay.
Because I'm going through this whole issue here because of the GPS for reasons unknown. Additional exclusion zones, changing
There's no
companies.
exclusion zone now. That's not an exclusion zone at the City Hall. I didn't order that.
Okay.
Okay. What I've said is.
And my current one is.
Hold on. I just want to make sure you understand. What I am saying is that you may not go there and threaten, harass, or annoy anyone. So if there is evidence of that, if someone at City Hall sees that and they have valid evidence, they can present that evidence, and that would be a violation of your bond.
I understand. So I'm just stating that they said there's no issue with the current company. I had billing arrangements made through a third party. So I'm covered through trial. If I change now, I'm not going to be able to pay it, and it's going to be a moot point. It's going to be an issue. I'm paid, I'm current. It's August 12th is the trial date. We're almost there. And like I said, for the current situation, the GPS wasn't the problem. It's how they're interpreting the data. Because why am I going in front of the court just because I drove in front of City Hall? That makes no sense.
Well,
that's the only issue here.
That's not the allegation.
It's how the data is interpreted. So the GPS isn't the problem. They've even stated this. And like I said, I spoke to his office. Did your office not say that was in full compliance with my current company?
We're not going to do that.
I can't switch at the moment. And that's the issue.
Okay. You can, and you will, or you will not be in compliance with the condition, which is that you will use a specific GPS that is requested by Mr. Facundo. Now, I know that what you are claiming is that all you did was drive by. What I have heard from them that's not what they're suggesting. They're suggesting that you did even more. We have evidence from someone. Now, I'm not going to, for that reason, I'm not saying that's enough to exclude you, but I am telling you, what have I told you that I don't want you to do in and around City Hall?
Annoy people.
Well,
that
or
was your
threaten
term.
or harass.
Okay.
Okay. Very good. All right. So you understand what is required by you, and we will see you back here for your next set.
I can't switch companies at the moment. It's not feasible, like I said.
Okay. We'll work with pretrial services to see what you need to do to make it feasible. All right. They think it is feasible. That is why they are requesting it. They're not doing it as a punishment to you.
Okay.
But what we want to do is make sure that the community is safe. That is what this is based on. All conditions of bond are based
I understand.
on community safety.
I understand. It's no issue. It's like I said, we're almost at trial, and now I'm going through all of this issue when I'm paid in full with the current device. And they told me, you said, talk to him to work it out. Well, I spoke to them. They said I'm in full compliance with the current device. And if I haven't done anything to anyone, I wasn't annoying, harassing, or doing anything to anyone at City Hall, right? I wasn't, so there's no issue here.
Can I just get a point of clarification? Mr. Dickerson, is it your testimony under oath to this court that you never got out, that you never set foot outside of your vehicle at City Hall?
Correct.
Okay, I just wanted to clarify that on the record.
I drove by City Hall, and this just doesn't make sense, like I said.
Okay.
Full compliance, you said speak to him,
Well,
he said full
I don't find that
compliance.
there is evidence enough to do an exclusion zone. I have not done that.
Okay.
Okay.
All right.
All right. If you'd step back, we've got to move to our next case. Need anything from me? No. Okay.
I appreciate it.
Yeah, no problem. Thank you, officer.
So as per just previous discussion in the office, I'm almost sure. Right, August 12th, almost. Current company's full compliance.
Can we get up those defendants for Mr. Nichols?
Cortez. There it is, I was gonna tell you.
We're gonna take one plea, and what's the other one?
Jury paralysis.
Oh, we're just gonna talk about status. State, what's the status of the
Quiet, please.
Jody Paralis and DNA?
We just checked earlier this month, Judge. We do not have a report. I don't have a date yet. I can reach out to the lab to try and get one.
Okay. Well, let's get on it. You see, while he's been out, an ag robbery. Also, then there was an aggravated kidnapping allegation. It's only an allegation, but this is someone with the time we have, the gravity and severity of the charge in the first place, that we want to put a priority on for the safety of the community.
And Judge, I will inform the court, my understanding is that DPS typically will not give us a expedited or specially expedited processing unless we have a jury trial date. So if the court were to put us on a jury trial setting, that may assist me in expediting the lab. No guarantees, but it would
Not
assist.
opposed to that, Your Honor.
Okay.
If we would.
Can we do mid-September?
And we will explain to Mr. Prowse that we've been unable to reach an agreement. We will set up for a jury trial. The punishment range.
That's right.
5 to 99.
That's right.
And in full transparency, I've told defense counsel, I'll tell the court, we are still making efforts to locate the complaining witness in the case. We haven't been able to do that so far. So also having a jury trial date, which is a date firm for us, would assist us as well.
Very good.
Sounds good. Now we got 6.
So we'll also set for the, Becky, can we do 2 settings? One, the trial setting of mid-September, and also a plea setting? No, just a status setting. Just a status setting for around our next docket in August.
Sounds good.
Okay.
Yeah. Yes, sir. I anticipate this may very well end up in trial.
So what?
I anticipate this case may very well end up in trial.
Okay. You can do a trial.
That's right. And this next one, Your Honor, has.
Coming off.
For the court's edification, this next woman has 6 cases, Your Honor, 5 thefts, 2 previous convictions, and a possession of controlled substance. And they're all open pleas to the court.
Oh, great. So we're only going to take the pleas today, and we'll do PSI.
That is good.
Very good.
All right.
So what happens when you say things like that?
Ms. Buse, can I ask you about these 2? So were these witnesses on these cases? Would you check for me?
Oh, okay. Yes, sir. Yes, Judge.
Just check and see if they're witnesses. Is Lydia here?
hate to say it, yeah, I think.
Okay,
It accomplishes the same.
Right, yeah.
Becky, on Jimenez, you had given me paperwork for new bond conditions, but we sentenced him today. Okay, so I'm not going to do those. On there's another one that you gave. Do we know if is she gone for good? Pretrial services. Would you ask her if she has time to return?
Your Honor, we're gonna go ahead and move Taylor to the jury docket. I mean, I'm sorry, Andrew Taylor, but we do need to get a 46B motion signed saying he's competent. Our negotiations are very close. This couldn't be done today.
Dr. Pan's report should be in there.
Do you have the report?
I don't, I can print it off for you.
Print it off and then we'll offer it as an exhibit. So Taylor, see, all these guys on the way out?
Well, that's what Deputy White was asking. Do you want Taylor on his way out?
Yes.
Yes. Taylor is already on the jury docket for 3 weeks out. This was, we said Taylor and Anya Hart are both mental health cases, obviously. So we'll just keep it there and hopefully I can get it, we're real close. Hopefully I get it worked out before then.
Yeah. Yeah. That's a different topic.
We're off of that.
Yeah, yeah, once we're, yeah, we're on.
Stay put. Linda, do you need me? Do you need me?
Judge, they were both subpoenaed witnesses in the case. One worked at Roxanne's house and the other was the nurse who performed the exam on the child.
But I will bring you memo, I will bring you out. Surprisingly.
Okay. All right, who are we ready on?
Either one.
Okay. Come on up, Mr. Perales. Mr. Daniels, you're going to need your client brought up?
Not yet, Your Honor.
Okay. Well, Mr. Perales, we are set here today for a pretrial setting. Counsel, what is the status of this case?
Your Honor, this case has been pending since 2023. We have completed discovery on this case. We've been provided a significant amount of discovery. We're waiting on a DNA from the state.
Comparison lab, yeah.
And we've had significant plea negotiations and been able to reach an acceptable plea agreement. So we would like to set this for a jury trial.
Okay.
Jury trial is where we go and 12 citizens would decide whether or not you were guilty or not guilty of this crime. Do you mind if we step back,
You
Your
may, of
Honor?
course, you can step back. This is. Good morning, how are you?
Morning.
Good afternoon, I guess now.
This is Miss Cortez, Your Honor.
Ms. Cortez.
Rosalie Cortez.
All right. Ruby, are you ready? Yes, sir.
Should be 6.
Four? 4 cases? There's 2 more you have coming?
Yeah.
Ruby, when I say are you ready, I mean, are you really ready?
Rinse and repeat. There should be one that's 5 of the charges should all be the same, and then one should be different. One should be a 2nd-degree felony POCS. Everything else should be a state jail felony theft of priors. If you kind of want to do that one last or something, or first.
State calls CR 19 22 56A, CR 20 4785A, CR 20 6108A, CR 20 6107A, CR 22 2341A, the state of Texas versus Rosalie Cortez. Can council please make their announcements for the record?
Philip Giebert for the state.
Matthew Nicholas for the defendant.
And are you the same Rosalie Cortez, who in the cases I just named is charged with 1, 2, 3, 4, 5 different cases of felony theft, 2 prior theft convictions,
Yes, sir.
and also charged in CR 22 23 41A with possession of a controlled substance, heroin, 4 grams or more, but less than 200 grams. Is that you?
Yes, sir.
Can you raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. All of these theft, 2 prior theft convictions are state jail felonies. State, what is the range of punishment?
180 days as minimum, 2 years as a maximum in a state jail facility.
Do you understand that that is the range of punishment that you face for the state jail felony charges?
Yes.
In addition, there is a possession of a controlled substance, heroin, 4 grams or more, but less than 200 grams. That is a 2nd-degree felony. State, what's the range of punishment for that charge?
Minimum of 2 years, maximum of 20 years in the Texas Department of Criminal Justice.
Do you understand that that is the range of punishment that you face for that charge? I have paperwork here that indicates you would like to enter into a plea bargain agreement. In each of those cases, I'm showing you that paperwork. Have you been through, in particular, have you been through the document entitled Written Admonishments, Waiver of Rights, and Stipulation of Evidence in each of these cases?
Yes.
And did you discuss what it says in each of the cases, the contents of these paperwork?
Yes.
On page 4 of all of these documents, there's a list of rights that you'd be waiving if you entered into this plea bargain agreement. I'm also showing you the heroin case, which is slightly different than all of the theft cases. There is a list of rights that you'd be waiving there as well. Did you know that you'd be waiving these rights in all of these cases if you entered into this plea bargain agreement?
Yes, Your Honor.
On page 5 of all of these documents, there's a stipulation of evidence. I will use that stipulation of evidence to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Judge, can I make a quick comment?
Yes.
Some of the plea papers come from our older form, so the state has written in an extra line about that admonishment. Some of the plea paperwork already has it printed. So,
Very good.
just for the record.
And you understand that that stipulation of evidence will serve as your judicial confession?
Yes.
All right. And then is this your signature on the final page?
Yes.
Did you put it on the final page of each of these documents?
Yes.
Including on the possession of heroin, which I'm showing you now?
Yes.
Ms. Cortez, this is an agreement. These are agreements between you and the state. I don't have to follow these agreements, but if I don't, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood? You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, Your Honor.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes.
All right. Are you a citizen of the United States?
Yes, Your Honor.
If you are not, a plea in a case like these could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence under Article 3914. Have you gone through and do you believe that in each of these cases, the state has complied with that obligation?
Yes, Your Honor.
And do you believe that Ms. Cortez is competent to enter into this plea today?
Yes, Your Honor. She's been able to help me with her defense.
Very good. The reason that we talk about the evidence is because you have the right to know what the evidence is against you. Did you discuss that evidence in each of these cases with your attorney?
Yes, Your Honor.
And do you believe your attorney is providing you with effective assistance of counsel during the course of these cases?
Yes, Your Honor.
According to your plea bargain agreement, in the theft 2 prior convictions, in exchange for your plea of guilty to those charges, it looks like in each of these cases, you're going to apply to the judge in each, and you're completely open to the court giving your punishment, which is a range of punishment from 180 days to 2 years in the state jail facility.
Yes.
Is that what you would like to do?
Yes, Your Honor.
That's your plea agreement?
Yes.
All right. To the charge of theft 2 prior theft convictions in CR 19-2256A, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no
Yes.
other reason? To CR 20-4785A, how do you plead?
Guilty.
You're pleading guilty because you are guilty and for no other reason. Let me just finish the question so that we're not talking over each other. NCR 20-4786A, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
There are 3 theft cases from Target, Your Honor, with different dates.
Those are target cases. NCR 20-6108A, how do you plead?
Guilty.
Pleading guilty because you are guilty and for no other reason.
Yes.
Okay, this one's not right. State, do you want to provide more evidence? NCR 20-6107A, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
To the charge, NCR 22-2341A, the charge being possession of a controlled substance, heroin, 4 grams or more, but less than 200 grams. How do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no
Yes.
other reason?
Yes.
Okay, State, what would you like to do in that remaining case?
Judge, I would ask that that you allow the parties to back out of that plea bargain agreement to submit a new clean one to this court. Seems that the plea paperwork was for one of the other 5 cases. It was an old plea agreement that got put in the wrong case.
Okay.
It's
We are
printed.
to the point that I have gone through all of them. I've taken the plea of guilty.
Well,
I have found in, it's okay, I'm
Sure.
gonna let you do it.
Yeah.
I have found that there is enough evidence to substantiate your guilt in CR 19-2256A, CR 20-4786A, CR 20-6108A, CR 20-6107A, CR 22-2341A. And is she going to be applying for our deferred adjudication?
Yes, sir. We will be asking for it for adjudication.
Be asking for it.
For deferred adjudication.
Okay, then I find in all those cases that I just mentioned, there is sufficient evidence to substantiate your guilt, but I don't find you guilty at this time. We'll handle the one that is pending after that correction is made. It's not a problem. Let's just get it right. That is CR 20-4785A. And we'll go off the record while y'all handle that.
Okay, thank you.
All right, let's come up on Mr. Taylor. Good afternoon, Mr. Taylor. How are you doing? Good. Okay, good to hear. All right, we're here. Really, let's go on the record, please. CR 22-4290F, the state of Texas versus Andrew Paul Taylor. Can counsel please make their announcements for the record?
Philip Giebert for the state.
Todd Dilly for the defense.
Okay, we're here today to consider whether Mr. Taylor is competent to stand trial. And Mr. Taylor, you have the opportunity to have a jury make that decision. Your attorney tells me that you've decided that you want the court to make that decision. Is that correct?
Yeah, yes, Your Honor.
Okay. If you would, could you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. And you are the same Andrew Paul Taylor who in CR 22-4290B is charged with assault on a public servant. Is that you?
Yes, sir.
Okay. And also in CR 22-3917C, charged with retaliation, harassment of a public servant. Is that you, the person that's charged?
Yes, sir.
All right. So we're going to move on this 4290 on the question of whether we will proceed depending on your competency. State, are you ready to proceed on that question
Yes,
before
sir.
the bench? Defense?
We are, sir, Your Honor.
All right. State, do you have any evidence to present?
Yes, state presents state's pretrial 1, which is the forensic psychological evaluation by Dr. Pan in this case. That was court ordered.
I've received that, Your Honor.
Okay.
And I have no objection to states 1 for purpose of this hearing.
State's exhibit pretrial 1 is admitted into evidence. Now, what I have here is the psychological evaluation that was done in this case. And I have reviewed it separately, taking a look at it now that it is in evidence. And would either party like to make any argument before I make a finding regarding competency?
Judge, just that you follow the Dr. Pan's recommendation that the defendant is competent in this case.
And I would agree with the state, Judge. That's what we're asking the court to do at this juncture.
Okay. Based on the evidence provided, the court finds that Mr. Taylor has sufficient ability to consult with the lawyer, and therefore he is able to understand what is going on. And court further finds that Mr. Taylor has a factual understanding of the proceedings against him. I'm relying on the report of Dr. Pan. And having considered Dr. Pan's report and the attorney's request that we not go to a jury trial, and that neither party's attorney opposed a finding of incompetency. Is that correct?
That is correct.
Correct.
The court now finds that the defendant is competent to stand trial. Is there anything else that we need to take up?
Not at this time, Your Honor.
No, we are currently in plea negotiations and hopefully we'll have a resolution, but if not, we'll be ready for trial.
Very good. And do y'all have a date set?
We do.
Okay. And
I believe it's early August.
Let me,
all right. So that you understand, that means that we're going to come back at a future date set for your trial on the merits of this case. That means what you've been charged with. If at any time your attorney is able to work out an agreement with the state, I'll be happy to take it. Okay. If not, then we will be set for a trial on that August date. Do you understand what's going on?
yes, Your Honor.
All right. Very good. Sounds good. Anything else you need to say?
That'll be it. Thank you, Judge.
All right. Thank you very much, Mr. Taylor. Keep taking care of yourself.
Hear anything, let me know.
Yeah, I'll reach out to you.
Thank you. Yeah.
If so,
Yes.
Yeah, I got you.
Judge, it is my understanding that Mr. Dickerson was told he was not to leave the building without going to pretrial services and taking care of the GPS as ordered by the court. One of our bailiffs did follow him out. He has left the building. He went to the back parking lot. I don't know if he's actually left the premises, but he was explicitly told not to leave the building without taking care of that.
Your Honor, he did not let me switch the device. I don't want to put words in Mr. Dickerson's mouth, but I believe he misunderstood what the court told him. He believes we're going back to the office to discuss payments and putting on the new device. He did not want the new device placed on him today.
So it was my intention for y'all to discuss how he could pay for it because of his concern and he's already paid up. He said there's not much money that he's paid up for it, according to his argument that it's time.
I told him, Your Honor, that he wouldn't be required to make a payment today. We're just here to install the device, and payment could be taken care of at a later date. You can make the payment online or do whatever third party, that payment link can be provided to them as well to make the payment. We're just there to switch the device, and the payment could be taken care of at a later date.
Okay, in fairness to him, I didn't give him a timeline, so I ask you to please give him notice that he has 24 hours to change that device.
Okay, and if he does not come back by the end of the day tomorrow, bond violation would be submitted to court?
Yes.
Okay.
But I want to take the responsibility. He could say, I didn't say when he has to have it changed. So he has 24 hours in fairness. And I know that y'all have contact with him, so please reach out and let him know that's the timeline.
Okay. Well,
thank you.
Thank you, Judge.
Lesson learned for me.
Chairman, we approach again on Ms. Cortez. I believe that the date has been corrected.
Who's the stipulation for a duplicate case?
I don't think it's just the date, right?
Is that the old one?
Yes.
Here it is. This is the old one if you wanted to. Okay. Yeah, it should be the correct stipulation of evidence.
That's right.
Yeah.
Ready? All right, we're back on the record in the cases of State of Texas versus Ms. Cortez. Ms. Cortez, your attorney and the state stepped back and made corrections to CR 204785A. That is a theft, two prior theft convictions in which you are alleged to have appropriated stock and inventory from Home Depot on April 21st, 2020. Have you had the opportunity to go over this new paperwork with your attorney?
Yes, Your Honor.
And so to this charge in this case, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
All right, we just need to get that correct. Having found that there was sufficient evidence in this case, I found there is enough evidence to substantiate your guilt, but I don't find you guilty at this time. What I'm going to do in this case and all of these cases is to order a PSI. We will come back after that is completed and we will do your sentencing at a future date. Understood?
Yes.
Yes.
Okay, as long as that should get you. Anything else we need to take up?
Nothing from the state.
There you go.
All right, thank you very much.
Thank you, Your Honor.
We get the opportunity to speak to Mr. Prowse.
Yes, Your Honor, we have.
Mr. Prowse, can you come forward? All right, what's the status on this case?
Again, Your Honor, we have a court date for August 20th for a status hearing and a jury trial on September 23rd.
Okay, do you understand that timeline that we have here in front of us?
Yes, sir.
All right, very good. Then we'll see you at the status hearing. Your attorney can continue to negotiate with the state. And if at any time they reach an agreement, then you, the court will be willing to take that agreement.
Okay.
All right?
Okay, thank you, Your Honor.
Yep. Step back. Okay, that's everything, right? So this afternoon, state, I don't think you need to come back. The only thing that would be happening is the waiver of arraignment on Jasmine Richards.
It's not set for arraignment for Jasmine Richards, it's set for pretrial.
Which one was the Carlos Ramirez that he was coming back for?
He hasn't come back for any closing.
Vasquez, I apologize. For Brandon Vasquez, that one's the one that there's just an arraignment. And then what was the other? The Jasmine Richards, what's the status on that one?
I don't have any status. He's never approached me on a judge.
Who is it?
Ryan Daniels.
Yeah.
Ryan Daniels.
He keeps jumping in and out.
We had some negotiations and then he said he was going to go down the hall and then talk to his client again.
Okay.
That was
Well,
about maybe 10 minutes ago.
all right. Well, everyone. Uh-oh.
I believe we just recently agreed with the jury trials.
Okay.
I'm sorry.
Okay. Do you have paperwork?
No, we don't have paperwork yet.
Okay.
Start it right now, Judge.
All right. We have to come back from Vasquez and we have to come back. So let's take a break until 1:45 and y'all can get everything.
Great. Thank you, Your Honor.
Okay.
Sorry about that.
No problem.
Your Honor, no probation.
No.
Be needed for him. No.
I don't think for anybody.
We have previous use.
Yes, you may.
Thank you.
Thank you. Thank you all very much today. Very informative.
That's Lydia's back from pretrial services.
Hi, Lydia. Can you come up, please? I want to ask you about this one. Do you know what's going on there? What you?
Oh, I didn't put a bond.
Her bond?
Yes.
Okay. Can I ask your clerk what her bond is?
Yeah, of course.
Two. This page two and this page.
I don't know where the picture was at.
It might be in.
I don't have a schedule yet, so I'll have to have that. She don't know what's in it.
All right.
I'll check it out.
We'll come back this afternoon at, well, 30 minutes on that one.
Yes, sir.
All right, I need to give people a break.
Yes, sir.
Please.
Yeah, you want me to, do you want me to stay here?
One morning. All right, well, thank you, everyone. Thank you.
Sarah, post for your civil at 1:30 is running late.
Okay. All right, y'all have a good afternoon.
145, Judge.
1:45.
And I can just call it out. On the 8th. So on the initial.